May, it's Celeste calling from Judge Fidelo's client. I have you on the calendar for Melvin Rodriguez. I just want to confirm that you're going to be close to me.
You got a pen?
If you can prioritize this. Okay, and I haven't even confirmed if he's in the gallery, but we definitely just want to get this call one way or another prior to calling that sentencing hotline. Okay, awesome. Okay, thank you so much.
Thank you for the email, by the way. It got us all
Good.
positive movies. Yeah, it's only about that. Lines of that. Because to you, they're two very different churches.
Yeah, for sure. Okay, sounds good. I know, that's how it always works. Okay, see you shortly. Bye. Morning. So it's an interpreter case, so yes, and the interpreter's running a bit behind. She says she's gonna try to find coverage. I don't even know if he's in here. I haven't checked. Just go right now. Do we have a Melvin Rodriguez in the gallery? He hasn't even checked yet. What if he's not in here? The deputies had him as being out. Benz, can you verify Melvin Rodriguez? She believes he's in custody. Do you know if it's by a different name or the same name? Sometimes. Okay. And then we have a holiday PDI plea and trucker in the afternoon. Why would we do that? I have no idea. It's like a nightmare. Of course. Yeah, looks like she pulled it in yesterday, so it's there. Once it's filed in CCAP, it's done. Yeah. Unless things have changed in the intake court, but I'm not aware of any changes. She's coming over from the sidewalk now. As soon as she gets in here, we'll call it. And we'll give them until 8:30.
Morning, Vince. Good morning, Erin. Thank you, Celeste.
Morning, everyone.
Sure.
Good morning, Judge Caballos.
Good morning, Angela. How are you? Welcome back. Oh, of course. Just do right by me. That's all I'm saying.
Yes, the doctors were allowed to appear via Zoom this afternoon.
Thank you.
I do not have her contact information. Do you have that also? Just to verify, ERWESTENDORF@yahoo.com.
How are you?
And there's no period after doctor, correct, for the email address? Okay, then we should be all set. Thank you so much. We'll see you at 1:30. Thank
My
you.
daughter and another law student. So they're two law students. If you want to frisk them or something, feel free. You actually should.
reminded me.
No, so,
Oh, okay. So you're just gonna move to do it rather than make her do it, okay. Okay, that's fine.
so we have a Melvin Rodriguez in the gallery.
Should be.
Exactly. Same concept. And then restitution date we're choosing? Okay. Yeah, I got some information.
Do we want to pre-select a restitution date?
Yeah, it's a good idea.
How soon are parties looking to book?
Ian?
3?
And then we'll waive his appearance for that.
How about September 4th, AM or PM?
Celeste, what date?
September 4th,
1,
4.
4.
That's a
Yeah.
Thursday.
Afternoon's fine on the, gee, I'm gonna put that on your calendar for the morning.
Not open.
Weekend too. Good morning. You're here. You're in Fregoso.
10:30? Work for defense?
Sure.
Okay. Yes, we're going on the record for Rodriguez. Going on the record, calling State of Wisconsin versus Melvin Rodriguez Jr., case 25 CM1681, appearances.
Katrina Vogie for the state. Good morning, Mr. Mendez Rodriguez does not appear. He is out of custody. Judge, he was in custody. I have notes so that he posted his bail July 28th. I do not have any record that he has counsel.
The judgment roll does reflect that on July 19th, he was given today's court date. It is now 8:34. He has failed to appear. A bench warrant will issue for his apprehension. I will put in place a remand order. I will forfeit all bail previously posted. Thank you.
Thank you.
That bench warrant was sent your way, Judge.
Thank you. Are we waiting on victims or witnesses?
I believe we're all set. We're ready to
Oh,
all set?
That's what I figured.
Parties all set to go on the record?
Yes.
Calling State of Wisconsin versus Maxwell Anderson, case 24 CF 1692, appearances.
Ian Vance Curzan and Megan Newport for the state, and joining us at council table is Detective Joanne Donner. Good morning.
Good morning, Judge. Attorney Anthony Cotton and Jason Finley with Maxwell Anderson. He's here in person.
Good morning, everyone. We're present for sentencing. In preparation for sentencing, I have reviewed the sentencing memorandum submitted by the defense, the pre-sentence investigation underlying this matter, as well as the numerous letters that were provided in support of the defendant, as well as on behalf of the state's victim impact statements. Relative to this matter, there is a pre-sentence investigation. Has the state reviewed it?
Yes.
Any corrections or modifications?
No.
Defense, have you reviewed it with your client?
Yes, Your Honor. Attorney Finley went over it with Mr. Anderson yesterday in the jail, and I discussed it again with him this morning.
Any modifications or corrections?
No.
Okay. State there is compliance with victim rights legislation?
Yes, Your Honor, the state's in compliance, and many of the victims' family are seated behind me.
I do see that. Please proceed.
Your Honor, I want to start actually with the defense motion that was filed after the trial.
Thank you for that. Actually, that is a really good place to start. So relative to this matter, the state did proceed to trial in an appropriate fashion. They had every right to proceed on both counts of the, and let me pull it up real fast.
The defense motion was document 49, just for the record.
I have it. I'm just, my computer for some reason does not want to allow me to open the document. So just one moment. So relative to this matter, clearly the defense and I came up with the same conclusion at the same time. My email was sent, I think, at the same point, pretty much as I received the defense's motion. There is an obscure statute, or a statute that I was unaware of, and I think the parties were unaware of at the time that this matter was proceeding. What the statute reflects is that, and one moment, for some reason my computer does not want to open this. Is that count 2 mutilating a corpse and count 4 hiding a corpse. By case law, it's appropriate that they both be charged and proceeded to on trial. However, the statute that's in play relative to this matter indicates that ultimately a judgment of conviction should not be entered as to both counts. Which count is the state seeking to have the judgment of conviction entered as to?
Judge, I think the judgment of conviction should be amended to dismiss count 4. And as the court's indicated, the state's position is that this statute makes these two crimes much like an OWI and a PAC, where they can be tried for both. The jury can find them guilty of both, but judgment of conviction for only one can be entered. So the state would think it's appropriate to amend the judgment of conviction by dismissing count 4, hiding a corpse.
At this point, I will vacate the judgment of conviction as to count 4. I will enter a judgment of, I guess, acquittal, just to take that off of, would it be a judgment of acquittal, or how would you phrase that?
It's
Just
a
an outright
dismissal.
dismissal?
It's a
So I'm going to
dismissal.
vacate the judgment of conviction, and I'm going to outright dismiss count 4 at this point in time. Okay, now that that matter's been addressed, thank you for reminding me as to that. Let's proceed as to the sentencing.
Thank you, Your Honor. I'm going to allow Sade Robinson's family to start off the sentencing by speaking. There are 3 members of her family that would like to speak. First, it will be Adriana Reams, her sister.
Thank you. And I did read her letter in preparation for today as well. Good morning, Ms. Reams. In order to begin, would you please state your first and last name and spell both for the record?
Adriana Reams, ADriannaReams.
Ms. Reams, what would you like to say?
When Maxwell Anderson murdered my sister, he redefined my definition of misfortune. No amount of financial hardships, disputes, or everyday struggles were even in the same realm as the effect of the loss he created. He made it,
And try to go slow, okay?
He made it to where my grandfather, who had just gotten diagnosed with cancer, lost his will to live his already health-threatened life. He was mentally sick and constantly bedridden. He could not even garden, which is a core part of his life that I have seen him do every year that I have been alive. He made me witness my hypersensitive grandmother on the verge of heart attack several times. Breaking down from the combination of the grief, other people's emotions, and the stress of having to deal with all the tedious responsibilities that he left behind when he ended my sister's life. He stole my father's ability to see the work he put in to raise Sade for 18 years pay off by having more than a year of seeing her be a happy, successful adult who still loved and appreciated him. He stole her father's ability to repair his relationship with her and be as close as they once were. He stole my mother's chance to ever finally become the mother that Sade always deserved. But most importantly, he stole Sade's chance to be an adult, to choose who she would and would not let into her life, to prioritize herself for the first time and do what makes her happy. As a result of his actions, I have had to grow up way faster than a 16-year-old should have to. I had to communicate with law enforcement, take care of my family, physically pick my mother up off of the ground, on top of trying to deal with my own loss, because he left them all too weak and broken to do anything. I had to quit my job because Sade got me that job, and the whole time I was there, I worked with her. I saw the effect she had on people, the way everyone lit up from her presence, the way she made everyone, from customers to coworkers feel special, which meant that I had to watch all of that go away. I had to watch and hear time and time again all of the people, many of whom I've never heard of, who were deeply pained by the loss of Sade because of what she meant to them, because of the way that she changed people's lives and generated happiness and erased people's bad days with her smile or her laugh or her hugs or her compliments or her taking things off of other people's plates regardless of how full her own was. I could not continue to be surrounded by people who hurt the same way I did because of the huge impact she had on them regardless of the extent of their interactions. I could not be in places where I could easily be walked over because I no longer had her to advocate for me, as she always did when I had not yet found my own voice. I couldn't go back to a job where I could no longer be getting to spend time with her, whether it was through car rides, shifts together, or sleeping over at her apartment because she always wanted to take care of me. He made it to where I couldn't go to school without people giving me looks of pity or no longer knowing how to interact with me because neither them or I knew what to say, for there was nothing you could say for what he did. He made it to where I cannot ride my bike without random but kind strangers stopping me because they feel the need to pray for me and my family despite not knowing us. He made it to where I cannot trust anyone, not just emotionally, but I cannot meet any person without the fear that they're gonna harm or kill me. Because all my sister did was meet someone, and as a result, he ended her life. He stole my ability to feel momentary happiness without feeling guilty for enjoying my life when I know Sade will never get to enjoy hers. He made it to where I cannot let myself stop doing things because I know that if I have time and space to think, I will break down and I will not be able to start again. He made me miss school and sports and a number of other things because I was searching for my sister's body that he unremorsefully hid from us, knowing that it would cause us extra pain. He made me feel extra anger for the fact that he could be so ruthless and relegate my sister, who took years to build up the confidence to feel like something, back to nothing. He makes me feel extra anger because he still shows no regret and sits here looking stupid without an ounce of guilt for what he did. He stole my sanity because I will spend the rest of my life searching for answers that I'll never get about what he did to my sister and why he did it. Because even though he has no life ahead of him, he still refuses to tell us these answers, even though doing so no longer has any ability to hurt him. He stole my resolve when he and his lawyer sat here and tried to paint my sister as some dirty, irresponsible drug addict or dealer, which could not be further from the truth. A couple of months ago, one of Sade's old teachers gave me a letter that she wrote to me for a school assignment when she was 15. She talked about some of her hardships, and she had so many, which is why it is especially hard to know that as soon as her hard work allowed her to escape many of them, her life was stolen. She said that she wants to be my role model and show me that anything is possible, that she wants to guide me through everything and be my support system. She said that even 5 years ago, she wanted to inspire me to be as independent as she was, and that she hopes she inspires me to do what I want to do in life. She said that everything she does is for me, and she will do anything for me. Even in her 19 years, she was still incredibly hardworking, independent, kind, supportive, selfless, resilient, and special. She continues to inspire me for the fighter that she was, but he took the guide and support system and role model that she was going to be for the rest of my life. He stole my big sister that always protected me and nurtured me and put me first. And he robbed her of her ability to do that and feel accomplished because she knew she was setting me up for a life better than the one she was forced to struggle through. He made it to where I cannot read that letter that I should have always cherished and smiled about without crying, because now it is just a reminder of everything I no longer have. He made it to where I cannot speak about her without breaking down or think about her without shaking, to where I cannot even grasp or understand my emotions because they are so overwhelming that I have to be numb to them. He made it to where holidays are no longer a celebration, but a mourning. He robbed my future kids of the opportunity to have cousins and an aunt to love and support them. And I will never not be haunted and affected by all that he took from me, but what hurts 10 times more is all that he took from her. Sade deserves to be selfish and irresponsible. She was working from the time she was 14 because she did not have anyone she could comfortably rely on, and she felt the need to be self-sufficient. People only ever took from her. They took advantage of her because they knew how kind and generous of a person she was. As she grew, she began to stand up for herself, but she never stopped showing people grace, never let one or a few bad people ruin her open-mindedness and magnanimousness for everyone she met. As she became more comfortable after saving up hard-earned checks and tips for years and buying her own car and apartment without any help from anyone, she began to dream bigger. She was able to think about more than just getting by and develop career aspirations while remaining responsible and paying all her bills months in advance, and still affording to finally enjoy the little free time that she had. Whether it was saving up for big vacations where she could go meet new people and experience new cultures as a social butterfly that she was, or taking a little breather and going out on one of her rare nights off between being a full-time college student on top of working over 60 hours a week between 2 jobs. She had every right to, and no matter what picture anyone paints, she was always responsible when she did. Her independence was finally allowed, and she was finally beginning to be happy. He ended it as soon as it started. He made it so she went through 19 years of hardships and abuse, and then after working hard to escape it, had no life left to be able to enjoy it. No chance to learn from whatever normal minor mistake she made, as any 19-year-old does. All she wanted was to be cared for and praised and appreciated, the way she had always done for everyone else, and he instead took her ability to do anything. She was the definition of a fighter, the definition of resilience. She never laid down or backed down, and to know that he took all her power away and stole her ability to fight for herself is the worst thing imaginable. There is nothing that can justify what he did to her, and what he did was much more than just murder or dismember her. He erased her independence, her ability to fight for herself. He tried to erase her existence and her value. Now I no longer have the opportunity to try and give her everything she gave me. I cannot show her how proud of her I am or how much I looked up to her. But much worse than me, she can no longer make herself proud or make herself anything. And the only one who took that from her is the man sitting right there. I beg you to not, I beg you to not let this man have any type of parole. You heard his ex-girlfriend describe the psychological abuse and self-harm he tried to impose on her. His behavior is clearly a pattern, and there is no way that after he has demonstrated the extent of what he is willing to do to a person so casually, he should ever walk these streets again. He still refuses to even admit what he did, and the jury and the public did not even have to be there to unanimously know what he did. He is clearly a danger to the public and should never be given another chance to cause anyone such tremendous harm the way he has done to my family. These law enforcement officers and prosecutors worked countless days working to find the truth. You, us, and the jury sat here for 2 weeks hearing all the heinous things he committed. Do not let any of that go to waste. Do not let the loss of Sade go to waste. This man should never walk free again. Thank you.
Thank you, Ms. Reams. You spoke well on behalf of your sister.
Speaking next will be Sade's mother, Sheena Scarborough.
First off, Your Honor, I would like to start off with, my name is Sheena Scarborough, SHEENA SCarbrough.
Thank you. Would somebody move that Elmo to the side, please? Ms. Scarborough, what would you like to say?
I am the mother of Sade. I've raised my daughters. We are light worker people. We are very angelic individuals. For us to even be here, I'm going to have to ask. I wanted to go before my daughter because I need her to be protected by this heavy demonic energy that is residual in this courtroom, this devil and his entire demonic family in this courtroom. It's very heavy to where I can't even talk. But Your Honor, I am asking that everyone in this courtroom be protected through the white light by this devil that sits beside. My daughter referred to you as a man. You will never be a fucking man. You're a pussy-ass bitch.
Ms. Scarborough, if you could direct your comments to me, please.
Yes, Your Honor. First off, Your Honor, I would like to thank you and the entire team for what we all had to endure, which was it was freaking torture to even have to be dragged through what we were dragged through. This demon and his whole ass attorney, they knew exactly what he did and what he was responsible for. They took us through extreme agony and pain. We are already dealing with so much trauma. There's no such thing as justice with what you did to my daughter, what you have done to my family. I have bust my ass for over 20 years to raise the best possible angelic light worker kids that do nothing but good. My daughter had to cross your demonic path. You plotted and planned to kill, dismember, then you disrespectfully spread my daughter across the Milwaukee like a piece of trash. How dare you? My daughter was everything. She was everything to all of us. As my baby explained, she had a different impact in each and every one of our lives. There's so many strangers and individuals in the community that I have engaged and met that she has touched and impacted. This has affected the world, the community in such extreme ways. There's no way in hell we should have even ever went through this freaking trial that you drug us through. You knew you were guilty. You're negligent, mammy and pappy, them demons. I'll deal with them later. But I want you to know that you can no longer hurt my baby. She's in heaven. She's protected. We roll deep. My ancestors roll deep. When you touch my daughter, you fuck with the wrong family. We ain't no pussy bitches, and you should have never touched my daughter. My daughter helped everyone. She fed homeless, she worked 2 jobs, everything Adriana said. The community knows who my daughter was. Everybody knows who my daughter was. How dare y'all even pull that whole shit about that meth? You will not drag my daughter's name down, trying to plot and set up stuff. You gonna carry my daughter's name the correct way in her legacy. You and your family will be held fully responsible for the rest of your life. You will be eternally haunted by myself, my ancestors. I know you cannot sleep at night. They have already been at you. You will never get peace. You will never sleep. You no longer can harm and hurt my innocent baby. You took advantage of her. You manipulated her in the worst possible way. You're a coward. My daughter is a hero. My daughter is a hero. She has saved so many other women from this demonic serial killer that there's no telling how many more people that he has killed. If you had any type of decency, but you are a devil, if you had any type of core piece of anything left in your demonic soul, or if your parents, your devil parents had any type of respect, I don't even know how they could sleep at night, knowing what type of demon son they raised, and then tried to cover it up. Y'all tried to flip that house. Y'all done did so much whole shit, it don't make no damn sense. All y'all karma is gonna be a bitch. And I'm getting each and every one of you eternally. I'm getting the whole entire family tree. Know that. Your sister, all them, each member of your family tree will be eternally hunted by my ancestors. We're light workers. I don't even have to touch you. The spiritual realm already been at you. I can see it in your eyes. You can't even sleep at night, you hoe ass. Judge, I did want to thank you and the entire community, the officers, the team, Ian, Donner, this whole entire community and team has stood 10 toes behind us. This has been extremely traumatic. This is not even my character. I don't move like this. I've been advocating and helping others my entire life. I come from a mental health background. This was not supposed to happen. This was not a part of our plan. Me and my daughters had goals. They are both very academically gifted and talented. They are overachievers. For this to happen, and we have bust and worked our behinds off in life, and then to have all of this noise about the millionaire murderer's son comes and takes my daughter. I don't give a freak about what your color status or how much money you got. You ducked with the wrong family. Because I don't play. You thought you was gonna get away. But I'm gonna respectfully request that you confess where the rest of my daughter's crown is, if you have any respect left for me and her father and her sister and the rest of my family in this community. You've already done the worst. You can at least give us that much. You have messed the entire community up. People can't even take walks and go to the park, and everybody's in trauma. This was not your first time doing this. And all your dark is going to come to the light. If you or your devil parents had any type of decency of respect as humans with morals, there's nothing else that there's no excuse for what you did to us, what you did to my daughter. My daughter is now protected. You can't hurt her. You can't take advantage of her. But know that you messed with the wrong one. You weren't getting away with this one. And you will be dealt with eternally, like I stated. But your Honor, Judge, I'm asking that this demon be respectfully returned back to hell as soon as possible. That's what I'm requesting through the court. Please return him back to hell as soon as possible. No possibility of life without parole, the maximum. And this devil should not be given any more special millionaire privileges being held in certain populations. He needs to be, not he, but that devil needs to be placed in the population with the rest of the demons that harm and hurt individuals, the murderers, the serial killers, the felons. You are not on no special privileges. Your money is not going to protect you. It's a done deal. Sade's justice is just now beginning, and you and all of your family will eternally pay for what you did to us.
Thank you, Ms. Scarborough.
Carlos Robinson, the father of Sade Robinson, will speak last.
My name is Carlos Robinson, CarlosRobinson.
Mr. Robinson, what would you like to say?
I've started my speech multiple times since the trial. My daughter was an amazing person. She lit up every room she walked into. She changed my life from her birth. Literally changed my life. She gave me a reason to think more of make me realize life is bigger than myself. We had an unbreakable bond, me and her. Talking to her was like talking to myself a lot of times. I used to tell her she was the innocent part of me. people lose their children. That's sometimes a part of life. I understand that. But to lose your child in this manner is unthinkable. No, I've tried therapy and all kind of treatments, and it's nobody can help me get through this process because everybody says nobody has ever been through this. What he has done is inconceivable. And to know that there's a chance I might not even have her completely to be able to put her at peace brings me night terrors and constant mental chaos. He has this. My daughter had a lot of life left to live. We talked a lot about her future. When she decided to come to live with me, and I got custody of her, I started to take her to colleges and things like that. And because before then she had no goals to go to college or anything like that. So I took her to like Howard University, FGCU, and she got the experience, and she started to change her perception of her goals and what she wanted to be and what she wanted to do. She had so much life left to live, so many goals that was taken from her. And to me, it's not just that she's not here, it's the way that she's not here. I can't wrap my mind around it. Somebody that does something like this doesn't even deserve. I think death is a way out. You deserve what you get. He deserves the punishment that he gave to my daughter. Everything that he did should be done to him. That's how I feel. To me, that's justice. I don't feel like he has a right to walk around and breathe air, eat breakfast, brush his teeth. He doesn't have that right. The moment he done what he did, he lost that. Any basic human rights. No man should be able to live doing what he did. That's just how I feel. And I try to make peace because I am a man of God, and I try to learn forgiveness. But I can't get past this. I can't.
Thank you, sir.
Your Honor, as the court is aware, there's three overarching things that the court must consider when sentencing an individual. The first would be the gravity, the seriousness of the offense. The court also has to consider the defendant's character, and the court has to consider the need to protect the public. The defendant was found guilty of 3 crimes. Count 1 carries with it a mandatory sentence of life imprisonment. The only consideration as it comes to count 1 is whether or not the court makes Mr. Anderson eligible for extended supervision at some point after serving 20 years of initial confinement. The state's request and recommendation of the court today is to impose life imprisonment and not make the defendant eligible for extended supervision as it goes to count 1. As to count 2 and count 3, the state would be recommending the court impose the maximum sentences and run those consecutive to one another and consecutive to the life sentence on count 1. To begin with the seriousness of the offense, obviously the court was here for the jury trial. I want to just highlight what I think the most important things were as it relates to what considerations there are today at sentencing. On April 1st, 2024, Sade Robinson went to work at Pizza Shuttle like it was any other day. She had that job for a while. The day began like any other day. She left her apartment on Commerce Street, went to work, and then later on in the day was texting with the defendant, and they agreed to meet up after she got off work around 5 p.m. They went to Twisted Fisherman. They were there from shortly after 5 p.m. to 6:30 p.m. And then they went to Duke's on Water, Sade driving them both in her Honda Civic, and they stayed there until about 9 p.m. They left Duke's on Water. They went to Maxwell Anderson's house at 3161 South 39th Street. Again, Sade Robinson driving her 2020 Honda Civic, and they remained in his house for several hours. And what we know is that while at his house, Sade became incapacitated. She was grabbed, groped, had her clothing removed, until she was removed from his house around 12:45 a.m. going into April 2nd. She was taken from the defendant's house by the defendant in her own car and driven around the county. And the defendant chose to ultimately go to what was his secret beach at Warnemont Park and dispose of Sade Robinson in the early morning hours of April 2nd. He took her body down to the shores of Lake Michigan. He cut her up into pieces and disposed of her in the lake, mostly in the lake. And then he took her car, left Warnemont Park, drove to the north side of Milwaukee, set her car on fire on 30th and Lisbon. In the course of doing that, in the course of disposing of her vehicle, he also discarded her left leg in the 31st and Galena playground, just a couple blocks away from where he set her car on fire. He calmly walked away and walked to a bus stop and returned home by a bus, Milwaukee County Transit bus, and then went about his life as if nothing happened. He went to work that day at Dugout 54. Later that night, April 2nd, Sade's right leg was found on the shores of Lake Michigan at Warnemont Park. And shortly after that, on the night of April 2nd, she was reported missing to police. For the next several days, as her family and friends wondered where she was, there were searches underway, and additional remains of hers were then recovered at the 31st and Galena playground. The police investigation allowed them to learn that the defendant was the last person she was with, the last person she communicated with, and he was ultimately arrested on April 4th. Days later, her torso was found badly decomposed, washed ashore in South Milwaukee. He had cut off both of her legs, cut off one of her arms, cut off one of her breasts, and cut off her head. Her head has never been recovered. As you can tell from what you've read in the letters and heard today, Sade was a completely innocent victim. She died alone in an unfamiliar place. Her last moments had to have been terrifying. And then after being killed, she was disgraced in the worst way imaginable, having her body cut into pieces, having her head cut off by the defendant who tried to make her disappear from the world. So when the court is looking at the seriousness of what Maxwell Anderson did, you have to consider who Sade was. She was a 19-year-old young woman, totally innocent. And as you've learned through the statements today, the PSI, hearing her friends and family testify, she was just getting into adulthood. She had just gotten that apartment on North Commerce. She had just bought that 2020 Honda Civic. It was a point of pride for her. It was it was a marker of adulthood, a marker of independence. She was ambitious. She had dreams. She wanted to succeed. She wanted to be productive. She went to school. She worked 2 jobs. And as you know, she was adored and loved by everybody, by all of those around her, her coworkers, her family, her friends, everybody. This is the most heinous crime this court will see. It doesn't get more serious than this, and it shows that the defendant has a depraved heart, and he has demonstrated a total lack of remorse, lack of accountability, and the gravity of this offense supports never letting him out of prison. When considering the defendant's character, we look at, for one, his criminal record. He has 6 prior criminal convictions. They are outlined in the pre-sentence report, and I think it's worth going through some of those, all of those, and the other conduct that's described in that report to get an idea of his character, and then to look at how that behavior was reflected in what he did to Sade. In 2014, he was convicted of a disorderly conduct, domestic violence incident. There was a read-in charge of disorderly conduct. This incident involved a domestic disturbance where he became violent during an argument with his mother. He damaged some property, pushed his mother, got into a physical altercation with his mother's fiance at the time, and it resulted in that person sustaining an injury, and Mr. Anderson himself sustained an injury during that. He was convicted, as I said, of disorderly conduct, and he was given a fine. In 2015, he was charged and convicted with another disorderly conduct, a domestic abuse crime, criminal damage to property, and misdemeanor witness intimidation. There was another charge of criminal damage to property dismissed and read in. This incident also involved a domestic disturbance, this time with his grandparents, where he again became violent, threw things around, punched a hole in the wall, broke a phone when his grandparents tried to call the police, and then he left. This time he was placed on probation and fined. He was discharged from probation. Fast forward to 2020, he was convicted of disorderly conduct. He had a dismissed and read-in count of misdemeanor battery. This incident involved the defendant beating up a man on Wisconsin Avenue when the man purportedly tried to intervene in an argument between the defendant and a female that the defendant was with. There was a video taken by a bystander that showed the defendant on top of the victim, hitting him with a closed fist in the head while the victim was on the ground trying to protect himself. Ultimately, again, he was convicted of disorderly conduct. He was placed on probation. He had previously picked up an OWI first offense, and then in 2022, he was convicted of OWI second offense after being pulled over going 70 and a 30 after 2 a.m. He was given a breath test and came back at a .145, and during this incident was also cited for disorderly conduct for urinating on the interview room that he was taken to by police after his arrest. There is a 2015 incident mentioned in the PSI, it's not a criminal conviction, it's just an operating without a license forfeiture. And then the PSI also brings about this 2010 incident where he was caught at what appears to be an underage drinking party, and after being detained, became belligerent, vulgar with police, urinated in the police vehicle that he was put inside. Since being arrested for this case, he has been in the Milwaukee County Jail. There have been numerous instances of misconduct while in the jail. Some of those are talked about in the PSI as well. I was provided with approximately 21 incidents of disciplinary infractions during his time at the jail, usually involving verbal abuse to jail staff, name calling, non-compliance with the rules. There was one incident of him defecating on himself during transport after one of the days of the jury trial, and another incident where he had apparently damaged some property, an electrical box, in the jail. Generally, his behavior while he's been in custody for this case at the jail, he's been a nuisance. What I think is important to take away from all of that is that this was not an isolated incident of violence. He has demonstrated in the past that he is capable of acting violent. But I think what speaks most to his character is the depravity of what he did in this case. I think all of that shows he has a violent, dangerous character and also supports this court not giving him an opportunity at extended supervision. As far as the need to protect the public, it simply couldn't be higher here. As I stated, this is the worst kind of crime there is, done in the worst way, leaving a family and a community shattered and distraught, and the public needs to be protected from this type of behavior, and life imprisonment guarantees that. This incident had, as this court is aware, a tremendously negative impact on the community at large, on the public. The public was completely shaken by this. Members of our community, young women in particular, deserve to feel safe, deserve to feel like they can meet new people, go on a date, and not fear for their safety. And he took that sense of security away from countless people, and he does not care. The last thing I would highlight is the impact on the victim and the victim's family. Anytime there is a loss of life, it's going to have a tremendous negative impact on a family. But what happened to Sade Robinson was not just tragic, it was an unconscionably vicious act of violence that violated her dignity. He had her unconscious, was grabbing her, groping her, removing her clothing. He killed her. He then cut her body into pieces and sought to have her disappear. It was simply evil and heartless behavior. And anytime a child is lost, a family obviously is going to grieve and going to suffer. But in this instance, that loss of life was compounded by the brutality and the viciousness of what he did to her body after she was dead. And to add to that horrible reality of what they had to hear happen to her, they also have to live with the reality that her entire body has not been found. Her head, to this day, remains in an unknown location. And the fact that her head remains in an unknown location inhibits their ability to find peace, and it inhibits their ability to believe that Sade has found peace wherever her soul may be. And he's the cause of that. When you consider what her family went through, on top of losing a loved one, they had to deal with the agony, which was bolstered by the fact that they didn't know where she was missing, or what happened to her. And meanwhile, he's continuing on with his life as if nothing had happened. And all any parent or friend or family member would want to know in those moments is that their loved one is safe, or that they just want to know where they are. And it was and continues to be torturous to their family, to Sade's family, because they don't have that answer as to where all of her is, where her head is. And still to this day, there remain unknowns that will likely forever haunt them. And the family can't even say goodbye to her because part of her is still out there somewhere. And he's shown no remorse for what happened. He has not accepted responsibility for what occurred. And his failure to accept responsibility has further caused the victim's loved one pain and reinforces his heartless character, which we've already discussed and which the court must consider here today. Again, simply put, there is no more depraved of an offense that this court could see. The defendant murdered Sade, tried to rid the world of her being. It's the worst behavior any human can engage in. It shows he has no morals, no sense of dignity, no remorse, and there's only one sentence that is suitable for that kind of violent and evil behavior, and it's imprisonment for the rest of his life.
Thank you. Defense.
Thank you. We'd have Maxwell's father, Steve Anderson, start by making us, saying a few words.
Sir, please start by stating your first and last name, spelling both for the record.
Stephen Anderson. STEVENANDERSON.
What would you like to say, sir?
Thank you for this opportunity. On behalf of myself and my family, I'd like to say a few things. First, to Sade's family, there are no words that I can share that will reduce your pain. You are all in my thoughts every single day. Although it is not the same, having lost a boy that was like a son to me 10 years ago, I have some sense of what you are feeling. It took me a very long time to get past the pain that I felt for the person that contributed to his passing. I'm not asking you to forgive anybody or anything. That is between you and your God. To the court, in particular, to Deputy Allen, to Judge Crivello, thank you for your compassion and all of your professionalism. To Max, we want you to know that we love you and support your plan for self-improvement. In this, we hope for a path for you to become a positive influence for society, both while you are incarcerated and hopefully after. Thank you.
Thank you.
Thank you, Judge. As you noted at the beginning, we filed much of our remarks in writing so that the court would have a clear picture of what we were asking for in this case. I know that there's no way to put a number sometimes on the loss of life. It's a very hard task that the court has whenever being in homicide court, you're confronted with homicide cases on a fairly regular basis. And by putting a number of 25 years of parole eligibility, we do not make any claim that we know the magic number. What I would observe is, in terms of that recommendation, is this. When you set, first of all, the sentence in this case is a mandatory life sentence. The jury convicted him. That's required. One way or the other, whether he's granted the opportunity to be, and I use the word parole, obviously we understand that it means extended supervision. It's often used interchangeably, but we're referring to some future hope that Mr. Anderson would have the opportunity to be released from custody. And the point of that is that he will be supervised by the Department of Corrections for the rest of his life, no question about it. And he has been in custody now, obviously for over a year, in solitary confinement, which is about as horrible of a condition as a person could ever be confined in. There are basically the unit of the jail, the unit of the jail that he's in is one where there's mental health patients, there's people who are going through substance abuse withdrawals, and so it's a torturous way to exist. Obviously, there are very real safety concerns that Max has going off to prison. We've, I think, expressed some of that in our written submissions to the court, that is a real consideration, because at the end of the day, this is not mob justice in this country. People have the right to a trial. They have the right to the evidence to be presented, the right to be represented by lawyers, and the right to test that evidence, and the jury returned the verdict that it returned. And it's your job to determine the sentence. But I want to emphasize that whether you agree with our recommendation, the state's recommendation, or something in between, no matter what it looks like, Mr. Anderson is going to be saddled with this conviction and the supervision and the incarceration for the rest of his life. As he sits here, I struggle to wrap my mind around some of the case, just like everybody else. We heard the evidence. We sat through the trial, and I certainly appreciate the state reciting it again today, but I don't think any of us have forgotten it. And as you read in the pre-sentence report, I'm not going to get into the details of it, but you read Mr. Anderson's version of events. He maintains that he didn't commit the crime. And you can place whatever weight on any sentencing factor you want, obviously, but that's his position. The jury reached a different verdict, and so for purposes of my presentation, I don't think it's wise or useful to parse through the testimony and point out what I think are points of reasonable doubt. The jury rejected that, and they returned the verdict that they returned. What I would say is that when you read through the character letters that were filed by Max's family, and I listened to the remarks from Sade's family as well, beautiful remarks by some of her family members, and the character letters were beautiful as well. But so were the ones on Mr. Anderson's side. Every person who has known Max throughout his life, every one of these character letters speaks to a history and a background that wouldn't suggest that something like this would happen. His mother describes how when she would come to visit him, he had adopted dogs, how they were well trained, how they were obedient, how he talked about wanting to work in a nonprofit center someday, his abilities as a chef, his work history, his imagination. And you go through the other letters that were submitted, his younger sister who had written a letter and talked about Max's intellectual talents and how he was a good student, how things came naturally to him, and how he was a good brother to her. The letter from the grandparents who were mentioned here as part of an earlier case, but his grandparents talking about their positive experiences with Max growing up. And that's the theme, I think, that exists here in all of the character letters when I read through them, that Max is, before he was taken into jail, before he was charged with these crimes, and before this incident took place, Max's character was generally positive. He's a high school graduate. After graduating high school, he went off to the Navy, served in the military for approximately 2 years. And I think there's obvious mental health issues in his background. I think that's clear. His mother talked about what she thinks was a traumatic brain injury that he suffered at 3 years old. There's a documented history of ADHD. And you read during his military service the mention that was made about the suicide attempt that happened in the Navy, where Max had tried to hang himself with an electrical cord. So clearly, there are mental health issues that deserve treatment, and we know that prison is not the best environment for a person to receive treatment for their mental health issues and their AODA needs. I disagree with the state that there's a long history of violence by Mr. Anderson. I think there are some isolated criminal convictions, but all those criminal convictions are misdemeanors. He has no felonies. And they are all of the disorderly conduct variation, even the one that the state mentioned about the incident on Wisconsin Avenue that was prosecuted here in Milwaukee, that was settled for disorderly conduct with probation. The incident with his mother, fine only, disorderly conduct. So that is not a significant prior record. And I think that differentiates Max from a lot of other people that come in front of this court. You do see people often in homicide court with gang ties, long histories of gun violence, long history of juvenile misbehavior, and you don't have any of that here. You have misdemeanors. There obviously are AODA needs. I think all of these cases, if you look at the disorderly conducts that he's had in his background, every one of them basically involves either mental health or substance abuse. And I think that's a recurring theme that we see here and even saw a little bit in the trial. The copious amounts of alcohol that was consumed on the night with Sade, I think further underscores that there are certainly AODA issues here. Max's plans for the future, they're, I would submit, incredibly realistic given the circumstances that he's in here. He has continued furthering his education as one of his goals, writing books, continuing to learn foreign languages. So I think he does have realistic plans. And obviously the punishment that's been inflicted sitting here in the county jail in solitary confinement has been horrific. Really, there's been almost no human interaction. He sits in a cell all day. His human interaction is when a PSI author comes to visit him or one of his attorneys comes to visit him, but not even being able to have visits from your family, not be able to see people in a face-to-face manner other than the guards is truly horrible. And of course, the fear that we have of him being targeted in prison, we know that because of some of the publicity that this case has generated, and I know it's not a matter that this court can specifically address, but we would ask that as part of the judgment of conviction in this case, the court express no objection to the Department of Corrections choosing to house Mr. Anderson as they see fit. I know it's up to the Department of Corrections, but it is an important consideration in this case that even people who have been convicted of very horrible crimes, we are not a death penalty state, we're not a mob justice state, nor are we that way in this country. And I would hope that the Department of Corrections takes measures to keep Mr. Anderson safe. The compass evaluation in this pre-sentence report is certainly not as bad as you often see. In fact, most of the, and that's an actuarial instrument that is done to evaluate a person by the probation department. And it's on pages 39 and 40 of the pre-sentence report. He is rated unlikely in numerous categories of having issues with society and routines, unlikely to have any leisure or recreation issues, unlikely to have thinking and attitude problems, unlikely to have negative personality traits, even unlikely to have anger issues. And so that's those are the actuarial tools that you've asked the Department of Corrections to use by drafting this report. They come back and conclude that these are not significant issues that need to be addressed at some point. There's not a socialization problem. There's not an educational problem. And we know that from his background. You learned a lot about Mr. Anderson during this trial. He has a long work history. He's been basically a pro-social person since he went off to the Navy. He's held a variety of jobs throughout Milwaukee. People have known him throughout the community. He's been a bartender. He's been a server. He's worked for an insurance company. And so he does have a proven work history. He was also a homeowner. He was maintaining a stable residence. He was maintaining his financial obligations. And so he's not the kind of person who comes to court with such hopelessness in terms of their ability to function in society that I think we should give the life sentence for. So my recommendation, as I indicate, is for parole eligibility at 25 years. That doesn't mean he gets released at that point. All that means is that at some future date, 25 years, when he has matured and grown, that a parole board will be able to evaluate his situation and decide whether or not he should have the opportunity to be released. That's all that means. Doesn't mean he gets out at that point. He may not even get out at 30 or 35 or 40. It would be entirely up to that agency to look at his growth and his behavior in prison. What has he done? What has he accomplished? And if they conclude that that would be appropriate, obviously the victim's family would be permitted to play a role in that process as well. And they would be able to decide whether or not to release him. We're asking you for that mercy today and that opportunity for some future release. Thank you.
Thank you. Mr. Anderson, what would you like to say?
I would like to start by saying that from the bottom of my heart, my deepest and most sincere condolences go out to Sade's family, as well as everyone else affected by this tragedy. That being said, Your Honor, I took this to trial without ever once trying to make a plea deal of any kind, because I did not commit these crimes. And so I plan to appeal my convictions, while I hope and pray that further investigations not only prove my innocence, but find and deliver true justice.
Anything else you wish to say?
No, ma'am.
So relative to sentencing, I have a job. And what my job is to do is to hold you accountable. That's to punish you. It's to protect society. It's to find a way that you never come back here again to rehabilitate you. And it's to deter others from engaging in like behavior. At the point of sentencing, I have to look at different factors. I have to look at your past record. And I'll agree with the defense that the prior record on its face is not as egregious as many cases I see in my courtroom. Quite often you see a background filled with felonies and violence. But what I said was on its face. When you look at the record as it's worked through in the pre-sentence investigation, I'll agree with the state that there are some red flags that jump out at you that, that show a level of violence that maybe it may have been a precursor. You know, when you look at the original case mentioned from Pewaukee from March of 2010, it looks like it's an underage drinking party. And when the officers come in, they find a bunch of people hiding and they indicate they're about to do a search. And later there's people saying that they were being held in the home against their will. Kind of a weird comment to have on an underage drinking party. Ultimately, they find Mr. Anderson hiding behind an entertainment center. He's belligerent. He tells the police, "Fuck you, I hope you're proud to serve your country this way." He's then very coarse and his comments are obscene. He then urinates in a police vehicle and calls a female police officer a cunt. Inappropriate. Then we have the 2014 case that involves the mother, where officers are dispatched to a location. They enter the home, they see, they make contact with the mother. She indicates that her son was in the kitchen. Officers approach and the response is, "What are you gonna do, shoot me?" And he runs out the door. He then jumps into his mother's vehicle and apparently steals the mother's vehicle and drives off. The mother indicates that when she returned home from work, he was acting strange. He was sweating profusely. He argued, he punched a vase, he caused it to fall to the floor. She calls her ex-husband. He pushes the mother into a room and shuts the door. He prevents her from exiting. He then breaks the phone. He's continuing to scream and yell and throw things, at which point she calls the police. Ultimately, what we find is that he returns to the residence. He gets into a physical altercation with Mr. Foos. She's informed that he had crashed her vehicle into the deck at the rear of the residence and fled on foot. Ultimately, we find that the mother's fiance confronts Mr. Anderson and he throws that person to the ground. He's able to get back in the house and to prevent Mr. Anderson from getting in. He suffered 3 to 4 broken ribs as a result of the altercation. ultimately, they have to meet with Mr. Anderson at the hospital because it appears he suffered a broken collarbone. He's convicted ultimately of disorderly conduct because he says Mr. Foose pushed him down the stairs as he tried to gather his belongings. It's interesting when you see Mr. Anderson's comment about that because he just says that Mr. Foose just poked him. Sounds like a bit of a discrepancy there. Then we go on and we find the issue with the grandparents. And the grandparents call the police and they say that he needs someone to talk to about his mental health and that he's smashing a glass in the sink, causing it to break. He goes in the basement, he punches a hole in the wall. He breaks the other phones. They have to go to a landline at a neighbor's, ultimately to call the police. It just sounds like he is to some extent out of control. He's ultimately on probation. He's given conditions of no drinking. He's given conditions of having anger management counseling. He tells the agent other people probably deserve to do anger management. I don't. He then goes on and tests positive repeatedly. To look at his explanations are ridiculous. At one point, he claims that he accidentally grabbed someone else's Red Bull that had liquor in it. But going through the repeated indication, it sounds like Mr. Anderson's the guy that does what he wants, when he wants, and he follows his own rules, not the rules imposed on him. And that's a frightening thing. You know, I read through the defendant's version of what happened. And it starts off by indicating that he was skeptical to meet with the pre-sentence investigator because he did not receive a fair trial. And there's no reason to believe that this writer's report would be fair or impartial. You know, speaking about the trial, you know, there's a constitutional right to a trial. Every person charged with a crime has a constitutional right to a trial. And we do not in any way penalize anyone for going to trial. It's also a constitutional right to be represented by counsel. And Attorney Cotton did his job, which is just his job to represent Mr. Anderson. That's under our Constitution, the rights that exist. Now, you get credit for taking responsibility. You get credit for resolving a case early. You get credit for stepping forward and saying what I did was wrong. Because usually this first step in rehabilitation is taking of responsibility. And we didn't have that here. That's why it's important to read what his version is. So you heard him say today that he didn't commit this crime. What he said about the offense was that they met for food and drinks and they proceeded to his apartment. And that's pretty much all there is to say, he said. He offered no other information as to what transpired that night. He later said that he regretted he did not walk Miss Robinson to her vehicle when she left his apartment, and he believed it was at that point she was abducted by an unknown assailant, quote, either from the alley or from my backyard, unquote. When asked how he accounted for his presence in the area where Miss Robinson's vehicle was set on fire, Mr. Anderson said that he was set up. He stated he was in the area to buy marijuana, and quote, and all it would have taken was for someone to know where I lived and where I'd be in the morning, unquote. He would not tell the writer when or how he made the arrangements to purchase the marijuana, and then instead stated, quote, I plead the fifth. He then went on to point to things that he claimed were egregious errors at the trial. He claimed that there was a video that showed the photos on the phone and that the state only played stills of the video. That wasn't the evidence at trial. Am I correct? Yes. He claims that the still photo that showed his hand grasping Miss Robinson's breast was part of a video and it was only a still that was shown. Incorrect, correct?
You're correct.
Okay. He indicated that at trial it was flaunted, the difference in age. And when I read that, I was somewhat shocked because I didn't really find that that was pointed out at all during trial. I mean, it was mentioned how old she was, But other than that, I didn't think that that was in any way an issue, and it barely even made it into my notes. So I thought my point is, I thought it was interesting how his view of reality seems different from what I find truly transpired. And I found it at numerous points during the pre-sentence investigation. You know, looking through this pre-sentence investigation, his viewpoints were very inconsistent with the reality. You know, I think the first issue relative to the mother's fiance, that was credibility. You know, it sounds like he lied to law enforcement. You know, he's asked, have you ever been involved in mental health treatment? Have you ever been in a mental health facility? Have you ever received treatment? He responds in the negative, but then we have the mother indicating that he was in an outpatient at Rogers. He indicates that he never made a suicidal attempt or had an ideology of said. But then we read about in the Navy how he was dismissed from the Navy due to a medical release, which appears to be related to the suicidal attempt in trying to hang himself. You have him saying about school, I did okay, but then you look at the history of how he did in school and his grades were pretty abysmal. And just odd things, like he talks about how he purchased the home himself for $160,000, but the mother says, no, I told the dad to buy him the home. It just seems like he has a different view of reality than the rest of the world does. So when I look at the criminal history, which I'm bound to do, it reflects low-level misdemeanors, but the facts underlying those low-level misdemeanors are replete with points that raise your concern. I next have to look at whether he has a history of undesirable behavior, and I think I've charted through what basically I found in the pre-sentence investigation. As to his personality, character, and social traits, it appears that he has had employment. That's a positive. It looks like he jumps between bartending jobs at numerous facilities. But who is a person who would do this crime? You know, what's the character underlying that? How can someone get to a point of inflicting such damage on a person, not only killing the person, but then dismembering? And then after that, discarding the body throughout the community. It's unconscionable, is where it comes down to. I did read the letters that were supplied on behalf of Mr. Anderson, and I do agree. They paint a picture of a man who helped his family when in need, who cared for animals, who went out of his way to love and support his family. But they love him, and that's clear. And that weighs on his behalf. You know, the fact that there are people out there that care and love him, that says something good. You know, quite often we do trials or we go to sentencing and there's no one here on the behalf of a defendant, which is really tragic and sad. So it says something good that a family does still care about him. I have reviewed the pre-sentence and I've taken into consideration what's stated therein. I have to look at whether you're remorseful, and I don't think you're remorseful in any way. I don't think that you have gotten to the point of taking any form of responsibility for what transpired. You know, the investigation that was conducted in this case, it was a dedication by numerous law enforcement officers to work tirelessly to put together the pieces to determine exactly what happened underlying this matter. You know, I do think that jury trials, they do re-victimize the victims. You know, it's hard to sit and watch a trial. It's hard to see the details. And it's hard, you know, not even to have known Miss Robinson, to wipe from my mind what you saw during that trial. And I didn't love her. I didn't know her, but you did. And that's a hard last thing to have in your minds. So I do understand how trials do re-victimize the victims. So when I look at the character of the defendant, I find the character wanting. When I look to the severity of the offense underlying this matter, I do sit in homicide court, and I can tell you on a daily basis, you don't understand why things happen. You know, almost every case, the victims come in and they want to know why. Why did it happen? Why did you have to do this? Why did you have to get to that point? And more often than not, there's no answer. We never know. It never makes sense. There's never do you walk away and say, oh, I understand why that transpired. It just doesn't happen. I can also tell you that, you know, I've read through all these letters and they talk about give us justice, right? Give us what's due. But I can't give you justice. There's no way you will walk out of here, no matter what I do today, and high five each other. There's no way you walk out of here and you say, justice is served. Because justice would be having Ms. Robinson back to you. Justice would be having her with you for the rest of your lives. And you never get that. You know, to hear about her, she was an innocent victim. You know, she was a girl that I would hope all young ladies strive to be. You know, to hear about working 2 jobs, to reach her goals, to be going on for schooling and further education, but then to hear about how much she was loved in the community by almost everyone that touched her. You know, it was interesting to go through the letters because I got the letters that were from who I expected, you know, the mother, the father, the sister, the loved ones. I also got a letter from the real estate agent that worked with Ms. Scarborough. I got a letter from citizens. And I can't tell you, I really debated whether or not I would share this, but there was a letter from a citizen that doesn't know Ms. Robinson, never met her. And this is what he said, or she said, I don't know. The person signed it as Stargazer. In pertinent part, it says, Sade Robinson was not a torso. She was not evidence. She was a full, living, radiant human being. She had dreams, plans, and a future she was building with pride. She had people who loved her and that still love her, more than words can hold. And she had a right to live, to breathe, to laugh, to grow old. That right was stolen in a way so vile, so deliberate, that it tears at the fabric of what we call humanity. You, Maxwell Anderson, didn't just kill her. You carved her, and you discarded her like garbage. And you tried to erase her body from this earth piece by piece. And for what? Not even you had the courage to say. You sat there in court as if you were a man. You didn't snap, you planned. You didn't panic, you dismembered. And still you offer no answers, no remorse, no ounce of dignity that you stripped from her. But here's what you couldn't take. You could not mutilate her soul. You could not silence the scream of justice. You could not prevent an entire community from rising up in Sade's name. We know who she was. We know what she could have become, and we will not let your darkness define her. To the family, there are no words that can hold the weight of your pain, but I need you to know we see you. We mourn with you. We love you. You have the right to tears. You have the right to rage. You have the right to every ounce of justice this system can give. May you feel her arms in the wind. May you hear her laughter in your memories. May you know that she did not die forgotten, she died loved, and we will remember her always. Maxwell Anderson, you are not the center of this story. She is, and she will always be. Sade Robinson lives on in light, in truth, and in love, and you will be remembered only as a man who tried to destroy something beautiful, but failed. You know, I thought that was beautiful. And I think that it shows the impact that this had on the community. You know, that took time and effort and thought, and I think it put together a lot of what the community felt. So going back to what I need to look at. In formulating a proper sentence, I need to look at the character of the defendant. I need to look at the severity of the offense. You know, to take away a child is horrific. You know, you wouldn't wish that on anybody. To have a child not outlive the parents is a horrible thing. But not only did you extinguish her life, but you hid it, and you hid her body to be found. And I can only imagine every time a news report, every time something clicked that another body part was found, how it had to just re-victimize this family, how it had to just be like another shot to their soul. I can't imagine how horrific that had to be. And yet, I wonder which was worse, the not knowing in those first days where she was, you know. I can't even think of a word, horrific. It's beyond imaginable for a parent to think of not being able to know if your children are dead or alive, and then to learn that they were dismembered and disgraced to the extent that this poor girl, her body endured, is beyond understanding. So the severity of the offense, I'll agree. It's definitely at the top of some of the worst homicides I've seen in this court. Looking at the impact on the community, I read that letter because I thought it stated to a great extent what we're here about. You know, what my job is to do, it is to hold you accountable and to punish you. It is also to protect society. And that's about how do we figure out if at some point you're redeemable? How do we figure out if at some point you will change your mindset? You will get the therapy and education to be at a point where you will be safe to have in the community. Now, part of that goes into the fact that you don't take responsibility. You know, I listened to the evidence. I watched what was introduced during the course of the trial. There is no explanation that I've heard that's valid as to why you would be walking away from that burning car. You know, those photos were not of a girl in a video enjoying life. Those photos of you grasping the breast that was ultimately shaved from her body, with her face plastered into that, I don't recall if it was the ottoman of the couch, the way that her body was positioned, there's no explanation for that. I don't need to rehash the evidence. I've gone through all my notes from this trial, and I think that Attorney Vance Cruzan did a nice job of summarizing in pertinent part the details. But there's no answer that you briefly provided in this pre-sentence that makes even a hint, that even resonates with a hint of truth. So how do we protect society from a man who clearly has had darkness in his past, who engaged in behavior that is, it's the facts that you see written in horror novels. That's what we have to determine. And you know, it isn't easy. I can tell you that when you think about, is there ever something redeemable in a person? You'd like to say at some point there is. And I can tell you that at the points in life where I've come to the conclusion that there isn't anything redeemable, you know, you do think about, I think it takes away a little piece of my soul. How come I couldn't find anything good? How come I can't find anything that I can say at some point you'll be a better person? So ultimately at sentencing, considering the seriousness of the offense, your character, and the needs of society. This is clearly not a probation case. Probation would unduly depreciate the seriousness of the offense and isn't even allowable under our law. You are sentenced to a term of life imprisonment, and that is what the penalty is for a jury of your peers ultimately coming back and convicting you on first-degree intentional. In this case, I didn't see a restitution request.
We are asking for a restitution hearing, and we've pre-selected a date.
Thank you. We'll be setting restitution off to be determined at a later date. Relative to this matter, I have considered the seriousness of the offense. I have weighed your character, and as I've indicated, I find it wanting. I've also reflected on the needs of society, and are you a good risk? And sadly, you're not. As to my sentence, relative to the nature of the offense, you are not eligible for challenge incarceration. You're clearly not eligible for any substance abuse programming. Restitution will be determined at a later date. You do need to submit a biological specimen to the state crime lab and pay the surcharge thereof. You do have the right to appeal, and if indigent, you have the right to the assistance of the public defender. What you need to understand is that a notice of intent to pursue post-conviction relief must be filed in the trial court within 20 days after sentencing for your rights to be preserved. You have been convicted of a felony. You may never possess a firearm. If you do, you're looking at 10 years of imprisonment, a $25,000 fine, or both. You may not possess body armor at any time in the future. If you do, you'll be subject to 15 years of imprisonment, a $50,000 fine, or both. You cannot vote in any election. I'm going to waive all non-mandatory fees, costs, and assessments. I'm ultimately going to want payment for restitution first and foremost. So we're going to determine that on a later date. But due to that, I'm not imposing any fine. The fees, costs, and assessments will be payable during your term of confinement at a rate to be determined by the DOC. Pretrial incarceration credit.
I'll get that information to you.
Okay. So relative to one moment. Count 3, arson of property other than building. That's a Class I felony. On that offense, you are looking at a fine of up to $10,000 or imprisonment for not more than 3 years and 6 months, or both. Relative to that matter, the maximum is 18 months of initial confinement and 2 years of extended supervision. I am imposing 18 months of initial confinement and 2 years of extended supervision. One moment. As to count 2, which is a charge of mutilating a corpse, that's a Class F felony. That means upon conviction, you could be fined not more than $25,000 and imprisoned not more than 12 years and 6 months, or both. Relative to that, the maximum is 7.5 years of initial confinement and 5 years of extended supervision. I am imposing 7.5 years of initial confinement and 5 years of supervision. Relative to count 1, that is a Class A felony, the charge of first-degree intentional homicide. Relative to that, you shall be sentenced to imprisonment for life. And relative to this matter, weighing all of the factors that I must, looking at the Galleon factors, considering your character, the severity of the offense, and the impact on the community, where you stole a truly shining light, is what it sounds like. I am ordering that you will not be eligible for extended supervision. Counts 2 and 3 are consecutive to count 1. The date for the restitution hearing will be
September 4th at 10:30.
Have you determined?
Yes, excluding today's date, 484 days.
I will provide you with a written explanation of the determinate sentence for your review. State, what have I failed to address?
I think that's everything.
Defense, what have I failed to address?
Nothing further.
Celeste?
Nothing, Judge.
One moment, and I'll give you a copy. Is there a printer in the paper? Is there paper in the printer? You know, moving forward, just an idea. You know, Sade Robinson, she was working so hard for good. She was working so hard to achieve so much. I haven't heard a word about how she was involved in violence or any type of attack or any type of ugliness. Wouldn't it be great if we all move forward not thinking about retaliation or revenge or hunting people, but about let's emulate that spirit and move forward trying to be kind and gracious to all. I mean, that's clearly the effect she had on the community. If we all try a little harder to step away from violence and to be kind to each other, to communicate more, maybe our world will be a better place. Just an idea. Thanks, everybody.
Thank you.
Yes, me, my son, and my father.
No further questions, Your Honor.
Cross.
Good afternoon, Mr. Doherty.
Mr. Smith.
So I want to go back to several things that you said in your direct testimony, but first I want to start out with, you said in your direct examination testimony that you gave a statement to law enforcement after this, right? Is that correct?
Yes, sir.
And you say in your testimony to this jury that you were never read your Miranda rights. Is that right? That's what you just said to your attorney?
From what I can recall.
Well, you didn't say you didn't recall, right? What you said to your attorney was that you were never read your Miranda rights. Is that right?
Yes, I did.
Okay. I'm going to direct you to page 12 of the transcript of your statement that you, with the detective in this case, beginning at line 5.
Really quick, can I say something?
I'm going to approach it. I'm going to show you what I'm talking about.
Okay.
I've got to lay this for the record.
Okay.
Okay. I'm going to show your attorney. approach?
You may.
I'm going to let you read along. So this is where I'm reading from, but I'm going to read this. So you said
This is the
something-
interview?
Yes,
with-
this is the interview.
Okay. I was in response. I was talking about when they initially arrived to my home.
Okay. But just
Not
to be
this.
clear, what this says is, okay, well, let me do this. I want to read your rights, okay? And you say, home. And the detective says, and then we can talk about that after, okay? And you say, okay, buddy. And then detective says, so you have the right to remain silent. You say, hum. And then anything you say can be used against you as evidence. Yes, sir. You're entitled to talk to an attorney now and have him present now or anytime during question. Do you understand? Yes, sir. If you cannot afford an attorney, you can be provided with one without cost. Do you understand your rights? And then you said, after being read that, in the transcript of your interview with the detective, yes, sir. So you were read your Miranda rights, correct?
Yes, I was not read them initially when I was placed in handcuffs, which I was referencing to.
Okay.
Not my interview.
Your testimony to this jury not 10 minutes ago was that you were never read your Miranda rights. Is that correct? Never. That's what you said. That's not true, is it?
I was read my Miranda rights in the interview room.
Okay. Thank you. Now, another thing that you just said that I found to be interesting is you said that when you came back out of your house, after you'd gone in the house and armed yourself with a firearm, you said that you came back out and you said, can you please leave? And you were speaking sort of calmly to the jury in a sort of meek tone that you're speaking today. Can you please leave? And this is after you came back out, after you armed yourself with a firearm, you're asking him, can you please leave? Is that right?
Correct.
Okay. So I want to direct you. I'll let you look at it. I'm going to read it again. I'm going to show, tell your attorney to, this is your interview with Detective Gilberti. This is on page 50, beginning at line 16. This is going to be line 16 through line 23. Permission to approach.
You may.
I'm going to let you look at this and then I'm going to read it out loud because this is the opposite of what you just said. Starting at line 16, I'll give you a moment to read through line 23. All right, so your testimony on direct examination was that you were just asking him to please leave when you came out with a firearm, right?
Correct.
Okay. But what you said to the detective in your interview was, and I'll begin on line 16, detective, like when you came back out with the gun and he was still in his car.
Response.
This is impeachment.
Overruled.
Like when you came back out with the gun and he was still in his car, did he say anything to you? No. Well, sorry, Mr. Doherty, your response was no. The detective says, was there any communication? Mr. Doherty, your response was, I didn't communicate with him, I shot him. That's what you told law enforcement the day that this happened in your interview, right? You didn't say, could you please leave? You just shot him. Is that right?
That's what I had said in the interview.
Right. Okay. So I want to go back a little bit. This afternoon, the afternoon going into the early morning that this shooting happened, you were at your father's house, right?
Correct.
And you had been drinking at your father's house?
Earlier that day.
And you had been drinking some shots of Casamigos at one point in the afternoon, right?
Earlier that day.
Okay, but earlier that day, you had been drinking shots of Casamigos, correct?
Correct.
Overruled.
Earlier that day, you had been drinking shots of Casamigos, correct?
Correct.
Okay. And to be clear, where was your vehicle when you came back to your house?
Parked in my driveway.
And so your father drove you to your residence from his house, right?
Correct.
But it's a close distance, right?
Yeah, I could have walked.
Okay. All right. So I want to talk about some other things that you said in your direct testimony. You were very clear in your testimony 5-10 minutes ago when your attorney asked you, did you see a firearm, right? You said, yes, I saw a firearm. That was your testimony just, 10 minutes ago, right? Correct?
Correct.
Okay. Now, I want to take you again to your interview with the detective in this case. This time I want to direct you to page 35 of the transcript of the interview. Now, on page 35, do you have the transcript, or do you need to see it?
I have a copy of it, but I don't know exactly.
Sure. I'm on 35 at line 25 and 36 at line 3. All right, so Mr. Doherty, I'm going to read from this transcript, starting at line 25 on page 35. Detective Gilberti, this is his question to you. Okay, did you ever see a gun? Mr. Doherty, I cannot say I necessarily saw a gun, but if you're giving me this gesture, I've taken concealed weapons classes. I've taken defense classes before. If somebody approaches me like this, and that's your answer. So you cannot definitively say and honestly say to this jury.
Objection, Your Honor. Objection, Your Honor. Argumentative.
Sustained.
You cannot say definitively that you saw a gun, can you?
Objection, Your Honor. Same objection. Argumentative.
Sustained.
Judge, can we approach?
Come on.
So today in your testimony, you mentioned that you saw a shiny object when you first approached the victim's vehicle, right?
Yes.
Is that correct?
Correct.
Okay. But you never said anything at all in your initial interview with law enforcement about seeing this.
Objection, improper impeachment.
Overruled.
You never said anything at all about the shiny object then, right?
When
When you had your interview with law enforcement at the interview room.
I had been waiting and sitting in the back of a police car for 7-8 hours. I was in the interview room for 6-7 hours. I hadn't slept. I was beyond tired, and my recollection of what happened could have been maybe, I don't.
Okay, so you didn't say it then, but you're saying it now, right?
I said it.
Okay. Now, you mentioned in your direct testimony that you were concerned for your son and for your father who were present at the time of the shooting, right? Is that yes?
Yes, sir.
Okay.
I apologize.
But even by your own telling, there was never any threat by the victim made to your son, right?
Objection, argumentative, Your Honor.
Overruled.
There was never any threat made by the victim to your son, right?
Correct.
Is that correct?
I said correct.
And there was never any threat made by the victim to your father, right?
Correct. It doesn't have to be made to them, though.
Okay. Now, you would also agree that where the victim was parked was not your property, right?
The neighborhood is considered my property. I don't own the neighborhood, but it's my dwelling. That's where I live.
Okay. But to be clear, Mr. Payne never set foot in your house, right?
No.
He never stepped foot on that piece of grass in front of your house.
He may have.
Okay. Do you remember previous testimony in a hearing? In a courtroom like this?
Yes.
Okay. I am going to direct and show opposing counsel transcript of a previous hearing.
I don't know what he did when I went in the house.
Okay, I'll direct a question to you in a moment. I'm showing opposing counsel the transcript, page 156. Okay, so my question was, at the time, was that area that he parked, is that your property?
No, sir.
Okay, so you're saying it was not your property. You agree?
It wasn't my. I don't own the land. I don't own it. I was a tenant there.
I understand that. But you leased the property, presumably?
Yes, sir.
Okay, and with that lease, it doesn't entitle you to the entire neighborhood, correct?
It's a private neighborhood.
It's a private, is there a gate to get in?
There was until it was destroyed.
Okay, so at the time of this, you could just drive into the neighborhood, correct?
Yes, you could.
Okay.
It's still a private
And
residence.
that area that the victim was parked, that's not included in your lease, correct?
Correct.
Now, when you went inside your home to arm yourself with a firearm in this case, the victim didn't follow you, right?
No.
He stayed by his car.
Correct.
And so you went in, you would have had time at that point to call 911 if you deemed it necessary,
Correct.
but you didn't do that, did you? Did you?
I didn't think it was necessary at that moment.
Okay. What you deemed was necessary was to get your firearm, go outside, and kill it, right?
No,
So that's what you did.
it's not subsequently what happened.
So you went in the house, right?
Correct.
You armed yourself with a firearm.
Correct.
You went back outside the house.
Correct.
You aimed. Before you shot, you aimed. Yes?
Correct.
And then you shot Adrian Payne.
After I asked him to leave several times.
And again, we already went through your original transcript, but what you previously said was you didn't communicate with him, you shot him.
You have
right?
audio recording of it.
Okay. I'm asking the questions here. You said, in what we've already established in your previous transcript, you didn't communicate with him, you shot him, correct?
If you say so.
I mean, we can look at it again. Do you need to look at it?
No, I looked
Transcript
at it
of it?
already. You already showed me.
Okay, so you would agree. You said you did not communicate with him, you shot him, right?
Correct.
All right, I don't have any other questions. Thank you.
Redirect?
Yes, briefly, Your Honor. Your interviews with law enforcement was recorded, right?
Correct.
So your conversation that you had with law enforcement that spanned over several hours could be shown to the jury, couldn't it?
Yes, sir.
Okay. At the time when I asked you, had you been given Miranda warnings, is it your testimony that you thought when you were first encountering law enforcement, they never asked you a question as far as Miranda?
Correct.
But at some point throughout the time that you were in custody, you were at some point in the interview provided with Miranda warnings?
Yes, and I feel like, he tried to trick me with that question, which is how the answer came out like that.
And again, you've seen a video of outside, right?
Correct.
Could you hear the verbal altercation that you had with Mr. Payne?
Yes.
So you did, in fact, communicate
Yes,
to
I
Mr.
did.
Payne. Okay. In fact, you heard the testimony of Ms. Tara Walker, too, today, right?
Correct.
She also testified that you asked, why are you here, right?
Correct.
So you did communicate.
Correct.
Is it that you was probably confused when law enforcement was questioning you, possibly?
Yes.
Okay.
I was beyond exhausted. I was tired. I could barely keep my eyes open. It was like 10 o'clock the next day. I hadn't slept.
And again, that interview was recorded, right?
Correct.
Video recorded?
Yes, sir.
Okay. No further questions, Your Honor.
All right, so you can have a seat back at council table. All right, defense, call your next witness.
Your Honor, defense rests.
State wish to present any rebuttal evidence?
No, Your Honor.
So state rests.
State rest.
All right, let me have counsel approach.
This is more properly presented before a jury, but pursuant to Martinez v. State, 981 2nd 449 of Florida Supreme Court case of 2008, if the state fails to carry this burden of rebuttal in regards to not proving beyond a reasonable doubt the defendant did not act in self-defense, the defendant is entitled to a judgment of acquittal. It even goes so far as to a Florida Supreme Court case of 1974, Lynch v. State 293 2nd 44, to defeat a judgment of acquittal In a self-defense case, the state must present evidence from which a reasonable jury could conclude that the defendant was not in reasonable fear of imminent harm, or the force used was not necessary or was excessive, or the defendant was the aggressor, or the defendant was looking to retreat. Judgment of acquittal must be granted if the defendant presented a plausible case of self-defense and the state failed to rebut it with competent substantial evidence. That's what we have here, Your Honor. Mr. Doherty is charged with second-degree murder with a firearm. The defendant has presented credible evidence that the defendant acted in lawful self-defense pursuant to Florida Statute Section 776.012 and/or 776.013. Under Florida law, once a defendant introduces any evidence of self-defense, the burden shifts to the state of Florida to prove beyond a reasonable doubt that the defendant did not act in self-defense. So with that being said, reviewing the evidence in the light most favorable to the state, they failed to provide competent and substantial evidence from which a reasonable jury could find that the defendant was not in reasonable fear of imminent bodily harm, that the defendant's use of force was unnecessary or excessive, or the defendant was the initial aggressor, or the defendant had a legal duty to retreat and failed to do so. In this situation, therefore, no reasonable jury could lawfully reject the defendant's theory of self-defense and still find beyond a reasonable doubt him guilty. As such, pursuant to Mitch v. State, the state has failed to meet its burden under the applicable standard of law, case law precedent, and therefore a judgment of acquittal is proper. Thank you.
Judge, I think there's a misconception. Obviously, just because the defendant testified doesn't mean that I have to then put on a rebuttal case, which is sort of what it sounded like opposing counsel was saying. Obviously, the defendant's story is rebutted by the evidence that was already placed on by the state, particularly Tara Walker and the video that was presented into evidence where you can hear the encounter just before the shooting and the shooting itself. She stated that the defendant, came out and that he fired, not having been, there was no threats made in his direction, that the victim didn't have a weapon, there was no weapon found in the vehicle. All of this, a jury could find beyond a reasonable doubt that he did not act in self-defense. Further, by the defendant's own admissions in his statement, just because the defendant says it's self-defense doesn't mean it is. So while he characterized what he did on that day as self-defense, it certainly wasn't. If you look at the applicable law and the instructions that you're going to give the jury, that it has to be reasonable, and it's both an objective and a subjective standard. So the defendant himself has to reasonably believe that his actions were justified and necessary in the circumstance, and even if you found that that was met, objectively, a reasonably prudent and cautious person in the same or similar circumstances would have to feel the same. And his actions of going back in a house, arming himself, coming back and shooting somebody, that is not justified. That's not self-defense. So even if you just took his own words, he's not rebut the state's case that he was not acting in self-defense in this circumstance. I would point to, obviously, just going to the other point regarding the JOA, I'd point to Mackey versus State, the first district case, 277 Southern 3rd, 762. I say it's a depraved mind, regardless of human life, second-degree murder may be established by competent, substantial evidence that the defendant acted with ill will, hate, and spite, and that the circumstances surrounding the fatal act can prove the ill will, hate, or spite. In this case, you have the circumstances around it that show it. You don't have to have an express testimony or express statement that there was malice or evil intent, spite. You can look at the circumstances as we have here, and we can clearly see that this defendant was not acting in self-defense. So I ask that you deny the JOA.
Your Honor, briefly, I'll just add, these facts support the judgment of acquittal. 1:30 in the morning, size difference, uninvited. You can infer that Mr. Payne wasn't coming over to wish him happy birthday. Okay? Again, had no relationship with Mr. Doherty. His girlfriend told him not to come. Despite doing that, he still came. Even after Mr. Doherty went into the house, just think about that for a second. If someone is objectively questioning why you're present at a certain hour at someone's home, place of residence, your castle, no, he's not inside the home, but he's lying in wait as he comes home. Very close proximity to where he lays his head, where his child lays his head. His father is in his 60s. His son is 9 years old. He's questioning why you're here. And the threat of posturing yourself as if you have a right to be at someone's home without an explanation, that placed Mr. Doherty in fear. And if Mr. Payne didn't want any problems, if he didn't want any smoke, any issues to occur, when Mr. Doherty retreated into his home, Because he didn't just walk up to him with a firearm. He didn't walk up to him wanting a confrontation. He thought it was Tara Walker in that vehicle. She had been driving that vehicle for several months. Unknown to him, it was someone else who rolled the window down, hopped out the car, and surprise, it's not what you want, little man. Yes, it is an issue of what was said. Nobody in this room was there other than Mr. Doherty and Mr. Payne. Tara Walker wants you to believe that she was there when it initiated. She was not. She admitted he was already there. She claims to have been on the phone with him and heard some chatter, but she can't say conclusively what was said. But if you didn't want any problems, reasonable people would acknowledge the fact that when someone goes into their home and you are now on notice that you are not wanted there, he could have left. But instead of him doing that, what did he do? With his 6'8" frame, 247 pounds, he moves up closer to the man's driveway. That places somebody in fear at 1:30 in the morning. Coming home and somebody you don't have a relationship with waiting on you. And you ask him why you're there. By the time you go in that house, he needs to be gone when you come back outside. That didn't happen here. This is common sense. The way the legislature works with these gun laws, this is not like a random shooting that happened in New York, just shooting bystanders. Even Governor DeSantis is pro-guns. He removed the need to have a concealed weapon permit. For situations like this, he's at his home. Ask him to leave. Even Tara would agree. He asked, why are you here? All this chatter about you told law enforcement you didn't communicate. The video itself shows there was communication going on. Tara herself said that it was communication going on. Whether he was giving Miranda or not doesn't matter. He gave a statement. So that don't even matter. Your Honor. At the very least, before we let this get to the jury, if you find that it needs to get to that point, which I submit to you, you should not. But if you find it that it's necessary to let the jury deliberate, they should not be deliberating over second-degree murder with firearms. That is an overcharge. That is not what we have here, by any stretch of the imagination. Not that. Maybe negligent homicide, maybe. Something definitely lesser than second degree should go to this jury, not second-degree murder. He shouldn't be facing life for that. That's not what the people of Florida support. The public would not be.
Judge, I'm going to object to this improper argument talking about what the people of Florida would support.
Stan, let's confine our argument to the facts and what the standard is for a judgment of acquittal at the close of the case.
I have nothing else, Your Honor.
All right. Based upon the evidence that's been presented to the court and the standard that applies at the close of all the evidence, the court does find that there is sufficient evidence to allow the case to continue to the jury, so the judgment of acquittal will be denied. Counsel for the state provided a copy of, or a draft of verdict forms and a draft of jury instructions to the court. Mr. Thompson, did you get a copy of those?
Yes, Your Honor, I did.
All right. And did you have a chance to review them with your client?
Not really with my client. I did not.
Do you have a copy of them on your computer that you can pull up? Okay.
Oh, yes, Your Honor, I did send it to him.
Okay.
We discussed.
All right, Mr. Doherty, did you get a copy of that was sent to you by your lawyer?
Yes, Your Honor.
Was that a yes?
Yes, sir.
Okay. And did you have a chance to read through it?
Yes, Your Honor.
And did you and your attorney have a chance to discuss it?
Yes.
Okay. What I'm going to do is you have a copy of it now up, Mr. Thompson, so you and your client can see it?
Yes, Your Honor.
State, have yours up?
Yes, Your Honor.
Okay. So we'll just kind of go through it. I assume nobody has any objection to the caption?
No objection.
No objection from the state.
All right. And then there's the standard instruction on final instruction to the, or introduction to final instructions. Anybody have any objection to that?
No objection, Your Honor.
No objection.
All right. The next standard instruction has to do with the statement of the charge. Any objection?
No, Your Honor.
No, Your Honor.
Next instruction is the introduction to homicide instruction. Any objections?
No objection.
All right. The next one is justifiable homicide instruction. Any objection?
I don't have that in that order. So my page 5, it goes from the excusable homicide and then into second-degree murder on page 6.
The one you sent me had an introduction to homicide instruction, then a justifiable homicide. It's probably part of the introduction to homicide.
Okay.
If you go down
Yes.
in there,
I see. Yes.
I break it out as a separate instruction.
Okay.
I have the same thing.
Okay, So, but it's part of the introduction to homicide, but it's a separate little subsection that says justifiable homicide. Nobody has any objection to that.
No objection, Your Honor.
No from the state.
And then right under that is another subsection for excusable homicide. Any objection to that?
No objection.
No from the state.
All right, and then the next instruction is the second-degree murder instruction. Take a look at that. Tell me if anybody has any objections to the second-degree murder instruction.
No objection other than what's previously been argued.
I understand that you're reserving your right on the judgment of acquittal.
No objection from the state.
All right, and then the next instruction is the standard instruction on aggravation of a felony by carrying a firearm. Any objections?
No objection, Your Honor.
No objection from the state.
Next one is the standard instruction on possession of a firearm, discharge, and causing death.
No objection.
No from the state.
All right, the next one is the standard instruction on when there are lesser included crimes.
No objection.
No objection from the state.
All right, and then the lesser included crime is defined as manslaughter. Any objection to that instruction?
No objection.
No objection from the state.
All right, and then there is a repeat of the aggravation of a felony by carrying a firearm as it relates to the manslaughter. Any objection to that instruction?
No objection.
No objection from the state.
All right, and then there's the justifiable use or threatened use of deadly force instruction. Take a look at that.
I have this highlighted. I don't know, there's different language, and the defense has to affirmatively state what, if they're seeking the part B, which I put in as aggravated assault, just based on prior arguments that they had made at the stand your ground hearing. That would sort of be my anticipation of what they would be asking for regarding the forcible felony. But if that's not what they're asking for, obviously we'll need to go in and, change that.
That's why I'm asking the defense to take a look at it and see if they have an objection or if they're asking for any changes.
No objection, Your Honor.
Okay. I assume the state has no objection.
No objection.
All right, then we get to the standard instruction on plea of not guilty, reasonable doubt, and burden of proof. Any objection to that?
No from the state.
No, the standard, no objection.
Then we get to the standard weighing the evidence instruction. Paragraphs 1 through 5 were included, and then I added the sixth, or there is a sixth paragraph added that included making inconsistent statements in court. Does anybody believe that the other 4 paragraphs apply? I don't think that they do, but
I believe the 6 that we have are appropriate.
defense?
I agree, Your Honor. I don't see what the other ones were. That's all I received. I didn't receive the other ones.
Well, the other ones usually have to do with reputation for dishonesty, criminal convictions. None of that kind of stuff came out.
I have no objection.
All right. And then the next standard instruction is the defendant's statement instruction.
It's in the caption, I think, maybe, at the top.
Where it says defendant's statement.
Yes, Your Honor.
I have it on my copy.
I don't have it on mine. Well, I have it, the next page has it.
All right, there, you got it. Any objection to that instruction from either party?
Not from the state.
No objection, Your Honor.
Okay, that gets us to the rules for deliberation, standard instruction. Any objections?
No from the state.
None from defense.
All right, and then the standard instruction for cautionary instruction, any objection?
None from the state.
None from defense.
Standard instruction on verdict, any objections?
None from the state.
No objection.
And then the standard instruction on submitting the case to the jury. Any objections?
None from the state.
No objection from defense.
All right. And Mr. Doherty, you've had a chance to go over this as we've gone through it here in court. You had a chance to go over it previously with your attorney. Is that correct?
Yes.
All right. And you agree with the choice of lesser included offense for being manslaughter?
Yes.
Okay. And are you in agreement with the instructions as your attorney has indicated? And then for purposes of closing, I assume, counsel, you're going to again concede elements of the offense or the lesser included. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including but not limited to, 1, whether when the defendant made the statement, he had been threatened in order to get him to make it. And 2, whether anyone had promised him anything in order to get him to make it. If you conclude that the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. All right, I'm going to stop reading the jury instructions. At that point, I will pick up with the remainder of the jury instructions after the attorney's closings. As I indicated, both the state and the defense have now rested. The attorneys will now present their final arguments to you. Please remember that what the attorneys say is not evidence, nor your instructions on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defendant has spoken. Does the state wish to give their closing at this time?
Yes, Your Honor.
You may.
Your Honor. May I please report? Carol Walker pled with the defendant not to take his gun out. She pled with him, don't take your gun out. Over again, don't take your gun out, Lawrence. We were asked to come here. She pleaded with him not to shoot Adrian Payne that night. But he didn't listen. Instead, he proceeded to take his gun out, take deadly aim, and shoot and kill Adrian Payne. It wasn't justified. It wasn't in response to a reasonable threat. It was just because he was intoxicated and he was mad. Not in the heat of passion that would be justified by law, but just because that's how he felt like, what he felt like doing that night. Not justified. Now, this was a relatively short trial. You heard from 6 state witnesses, as well as the defendant, including Tara Walker. And obviously you heard from the witnesses yesterday, so you probably have fresh memories of what was said, but I want to go through and touch on what I think are important points for you to remember when you go back for your deliberations. First, you heard from Corporal Garrett Morris. He was one of the first responding officers on scene. Now, he came to the scene and he found the victim suffering from a gunshot, and he was still in his vehicle. Now, you heard from the testimony, he was a large individual. He was 6'8", and they had difficulty getting him out of the vehicle. They were able to ultimately get him out. He tried to render aid on the ground at CPR with another officer. Unfortunately, he was unsuccessful. Now, you heard as part of protocol for when responding to a scene like this, a shooting, that he checked for weapons on the victim's person. And you can actually see on his body camera video that you saw that he did check both a pouch that the victim had on and as well as his pockets. No weapons. You also heard from CSI Hannah Miner, who testified yesterday morning as well. She was the lead CSI in the case, and she was in charge of documenting the entire scene, including the inside of the victim's vehicle. And you saw her documentation of that scene produced no firearm. There was no firearm in the vehicle. There was a kitchen knife in the passenger floorboard that you heard from Tara Walker was put there by her after a dinner that they had picked up. You also got to see from CSI Miner's photographs sort of a layout of the scene. You got to see that the victim's vehicle wasn't parked right in front of the defendant's house, but down the street a ways, at least a couple of residents down. You saw that the vehicle wasn't on his property. It wasn't on anything adjoining his property. You got to see the distances between the defendant's door and where the victim had parked. You got to see her photographs detailing her search of the defendant's residence where the firearm was found. And you saw the firearm itself, which is in evidence. You heard briefly from Marco Quintanar, who was a neighbor in this incident. He didn't see anything, but he heard gunshots, which caused him to look at his surveillance camera, and he was able to find video that captured audio of this shooting. And of course, you heard from Tara Walker, the victim in this case, his girlfriend, the mother of his child. She told you that she responded to the area of the defendant's house after receiving a call from her best friend, Tatiana Mesa, that she then spoke with her boyfriend, Adrian, who said he was also en route there as backup to her. Now, you heard that She got there just after Adrian had arrived and saw the defendant sort of walking away after apparently having words with Adrian going back into the house. You heard she had a brief conversation with him. He was going to move his car so she could fit to park on the street there. And then you heard that's when things took a turn. The defendant came back outside the house. He didn't stay in the house. He didn't lock the door. He didn't call 911. None of that. Instead, he arms himself with a firearm, taking the time to do that. He comes back out, and when Tara Walker sees him, she notices that he seems to have a gun. And she says, and you can hear on the audio, "Don't take your gun out. Lawrence, don't take your gun out. We were called here." But then she told you he didn't listen. He does take the gun out. You can hear the escalation in her voice. While you can't see the incident, you can hear it play by play from her voice on the video and the shots themselves. And you hear just after that, after he's been warned, after he's been told while they're there, you hear the shot ring out. And then you hear screams. Because the defendant had killed Adrian Payne for no justifiable reason. And you hear that in that surveillance. You then saw on the video and you heard from her that she ran down to a neighbor's house. She tried to get help. And then she continued running, trying to get help from other neighbors. And then ultimately, when law enforcement came back, she was back to the car to try to render aid to her boyfriend, who unfortunately succumbed to the injuries. Now, you also heard from the medical examiner in this case, Dr. Marie Hansen. She told you about her extensive experience as a medical examiner since 1990. She told you about the autopsy she performed in this case. And she told you about the positioning of the victim's body when he was shot, that his arm would have had to have been up like this and to go through his torso for the shot. She said that was consistent with, and obviously she wasn't there, so she can't say specifically, but it was consistent with someone having their arm either perched on a door frame or on a steering wheel, just as Tara Walker said. She also said that based on the positioning, it's likely that the thumb was down. That's not a position that someone would be pointing a firearm, which we know that the victim in this case never had. But instead, a position of somebody that's by his car or in his car, nowhere near this defendant's residence, not on his property when he was shot. You heard from the medical examiner that the cause of death was that gunshot as it went through and pierced the aorta, and you heard that the manner of death was homicide. You also heard from firearms expert with FDLE, Kristen Killinger, just that confirmed that the gun that was found in this defendant's home was in fact the gun he used to kill the victim in this case, and that the bullet that was removed from the victim in his autopsy was in fact fired from that defendant's gun. Now, you also heard from the defendant in this case, and part of your job, as is your job with all the witnesses that testified, is to weigh their credibility. Now, the judge just instructed you with an instruction on weighing the evidence, and it goes through the factors that you look at when weighing the credibility of a witness that testifies. And that's your job as a juror, to go through that with each witness and determine what you find credible and what you find to be not credible. Now, I want to talk about some of those that are of particular importance, I believe, to this defendant's testimony. Did the witness seem to have an accurate memory? Well, you heard his testimony as he said certain things with his counsel, but then when I questioned him about it, I said, well, it had been a long day, I'm not sure, I might not have said it. Did you find that to be credible? Was the witness honest and straightforward in answering questions? Well, he was barely audible when answering questions from his attorney, but he was at least cooperative. But then when I asked him questions, you saw his response, talking around the question, not giving me direct answers, having to be impeached multiple times with his previous statements. Did the witness have some interest in how the case would be decided? Well, no one that you heard from yesterday has more of an interest in how this case is decided than the defendant, obviously. Did you find his demeanor on the stand to be credible? Or did you see the tears, if there were any, to be crocodile tears that he was trying to force to gain sympathy from you? What do you believe? Did his testimony agree with the other evidence in the case? Well, no, it was in conflict with the testimony of Terrell Walker, and that testimony of Terrell Walker is corroborated by the video and the audios from the surveillance video. And did the witness at some point make statements inconsistent? Well, several times. I mean, just out of the door in his direct testimony, he said he had never been Mirandized, but then obviously he was impeached on the transcript of him being read Miranda. He said that he, didn't initially, so they didn't try to talk to the victim when he came back out. He didn't communicate with him. He shot him. That's what he said just after this murder. But then after watching all the evidence, he gets on the stand and says he came out there and was trying to, talk, please leave, please leave. First of all, I question that is the demeanor that he came out and was asking Mr. Payne to leave. But also, Adrian Payne was not on his property. He was on a street that was not even touching his property, and he didn't have any less of a right to be there than the defendant. He also said definitively, as you heard in his direct testimony, he definitely saw a gun, but he never said that in his initial statement. What he said is he thought he saw the outline of a gun. He's not sure, to be honest, he's not sure. That's what he originally said, but after hearing the evidence and realizing what needs to be said in order to convince you that he was somehow justified in his actions, that's what he said on the stand. But it's not consistent with what he said before, and it's not consistent with the facts and evidence in this case. Now, from the evidence in this case, it is clear that this defendant is guilty of second-degree murder with a firearm. The judge just went over with you the elements of that offense as well as the lesser-included offense of manslaughter. But I want to take a minute and go through those with you as well and go through the facts as the state believes they apply. So the judge will instruct you and you have in your packet that you are to convict of the highest crime proven beyond a reasonable doubt. And that's second-degree murder. Now, here there's a lesser-included offense of manslaughter, but I want to be clear, and I'm going to talk about manslaughter, but I want to be clear. In jury selection and in these instructions, you're going to be told to not let sympathy or concerns about sentencing impact your deliberations in this case. So if you believe that we've proven this case beyond a reasonable doubt regarding second-degree murder, it is not appropriate to say, well, maybe he was scared even if it wasn't justified, or maybe whatever the situation is, he's, not that old. I don't want him to, go to prison for a long time, or whatever the case may be. That is not appropriate. That is not the consideration for the jury. You are to convict of the highest offense proven beyond a reasonable doubt, and that's second-degree murder. But I'm going to talk about manslaughter because we have proven the elements of manslaughter as well, as it is a lesser-included offense. So to prove the crime of manslaughter, the state must prove it's just two elements. And there's a couple of big differences between manslaughter and second-degree murder. First, there's just two elements. There's three elements to second-degree murder. Manslaughter does not require any type of mental state. So second-degree murder requires that he acted with what the law calls a depraved mind. I'm going to talk to you a little bit more about that in a minute. But manslaughter does not require that. It just requires that A, Adrian Payne is dead, which is stipulated to. Obviously, we've established that he is deceased, and that the second element is Lawrence Doherty intentionally committed an act or acts that caused the death of Adrian Payne. Now, obviously, in this case, that act is taking his gun and intentionally shooting him. That's it for manslaughter. Now, you're going to see that for second-degree murder, there is an instruction regarding heat of passion. That doesn't apply to manslaughter. So the two things that you can consider for manslaughter for elements are that Adrian Payne is dead and that the defendant committed an intentional act that caused the death of Adrian Payne. We've proven manslaughter. We've met those elements. But you should not convict him of manslaughter because that's not the highest crime proven. So I want to talk about second-degree murder. I'm going to put it up here. I know you have it in your packets, but I want to talk about it in a little bit more detail. And if you can't read it exactly on the screen, again, I say you have it in your packet. It is on page 3 of your packets. But so there's the same, the first element is the same, that Adrian Payne is dead, and that the death was caused by the criminal act of Lawrence Doherty. That criminal act is taking his firearm and shooting him while he's sitting in or by his car. The third element is the difference. That there was an unlawful killing of Adrian Payne by an act eminently dangerous to another, demonstrating a depraved mind without regard for human life. So, ladies and gentlemen, I pose to you that obviously taking a firearm and shooting another human being demonstrates a depraved mind, and eminently dangerous to another and depraved mind is defined for you. It says a person of ordinary judgment would reasonably certain to kill or do serious bodily injury. A normal person knows if you take a gun, you point it out, and you pull the trigger, it's going to cause bodily injury, or it's going to kill him. It's done from ill will, hatred, spite, or evil intent. And I want to point out that these are ors. So you can find that it was done from ill will. He was upset that he was outside his house. Hatred, maybe he was that mad that he was outside his house. Spite or evil intent. You can find any of those. You don't have to find all of them, but if any of those satisfy the depraved mind requirement. And he certainly had that, and his actions demonstrate that he had that. And then finally, is of such a nature that the act itself indicates an indifference to human life. And again, some of these things overlap with each other. Obviously, again, taking a firearm, pointing it, and shooting at another human being shows that you're indifferent to that person's life. Now, with second-degree murder, we do not have to prove an intent to cause death. So that's not something you consider. Maybe he just wanted to injure him or whatever the case may be, if that's what you believe. I think the facts show that he took deadly aim and intended exactly what happened, but you don't have to find that. You don't have to find an intent to cause death, just that he had an intent to shoot him. So then there's the portion that talks about the heat of passion. And there are some subsections here, A through E, but each of them talks about an ordinary, reasonable person. So it's not just, well, I was scared, so I did it. That's not sufficient for heat of passion under the law. It's not sufficient to say, I was upset, and so I did this thing, and I'm excused from it being second-degree murder. No. There must have been a sudden event that would have suspended the exercise of judgment in an ordinary, reasonable person. Again, that language, ordinary, reasonable person. And again, I want to point out, too, all of these are ands. So you have to find all of them for these actions to be reasonable. A reasonable person would have lost normal self-control and would have been driven by a blind and unreasoning fury. So the question is not just, was this defendant in a blind, unreasoning fury? He was certainly not acting reasonably, but would a reasonable person have acted that way? No. There was not a reasonable amount of time for a reasonable person to cool off. This defendant took time. He went in his house. There was no threat at that point. He wasn't pursued. He armed himself. He came back out. There was no further threat. He's being begged and pleaded with to not do what he did, but he still did it. So he certainly could have cooled off when he went in the house. And then another and also has to be met. A reasonable person would not have cooled off. So say he was so upset by whatever interaction that they had out by the victim's vehicle before he went in the house. A reasonable person, when they go in their house, can shut the door, can lock the door, can do whatever, can cool off, before coming out and doing what he did. And then finally, he was so provoked that he did not cool off before he committed the act that caused the death. So it's not just a matter of, I was scared, this was a scary situation, and therefore I did this and I should be excused of second-degree murder. No, you have to look at it based on a reasonable person. And the defendant in this case and his actions were anything but. So the defendant in this case took the stand and claimed that he was acting in self-defense. He was justified in his use of deadly force. But that is not the case when you look at the facts. The defendant's actions were not reasonable. The judge has given you a lengthy definition of justifiable deadly force. That's on page 8 of your packet. And for something to be justified, it must be both an objective justification and subjective. And I want to go through a specific paragraph that is in your instructions that explains that and how that works and what you're to consider. The second from the bottom on this page, I don't know, on your packet, but it starts with in deciding. So the judge has instructed you, and you're going to have this in your packet, in deciding whether Lawrence Doherty was justified in the use or threatened use of deadly force, you must consider the circumstances at the time the force threat was used. So that's important because he didn't use the force, when they first had words and he decided to go in the house. This is after he had gone back in the house, had time to cool off, arm himself, and come back out. And other people, were present at this point, including Tara Walker. The danger need not have been actual. However, to justify the use or threatened use of deadly force, the appearance of imminent danger must have been so real that the defendant actually believed the use or threatened use of deadly force was necessary. So first of all, this wasn't threatened use of deadly force. I guess maybe it was in the moments just before he pulled the trigger, but this was deadly force. He did pull the trigger in this circumstance. And he himself must have actually believed in that moment that it was necessary to do what he did. Not that he wanted to, but that it was necessary. And beyond that, even if beyond just necessary in his mind, moreover, to justify the use or threatened use of deadly force, a reasonably cautious and prudent person under the same circumstances would have believed that the use or threatened use of deadly force was necessary. A reasonably cautious and prudent person. This defendant's actions were not the actions of a reasonably cautious and prudent person. That's for you to decide when you look at the facts of the case and you look at the evidence, but the evidence has shown that what he did was not the actions of a reasonably cautious and prudent person. The defendant in this case was not standing his ground. He was the aggressor. He was the person that initially approached a car parked on the street. This person wasn't knocking, on his door, wasn't standing on his lawn. He was sitting in his car with the window rolled up. He was the one that made even an initial contact. This was not an act of defense, and it certainly wasn't an act of reasonable self-defense. He took a life not to protect his own or to protect his family. He took it because he wanted to, because he was upset. His actions show a depraved mind, and he's guilty of second-degree murder. We ask that you convict.
All right, defense.
Your Honor, maybe pro smoke briefly.
Come on. Okay. All right, counsel, for defense, you may proceed.
Yes, Your Honor. I'm just grabbing right now. Your Honor. Good morning, ladies and gentlemen. Good morning. I'm going to stay at the podium this morning because that I really want you guys to hear what I have to say. Let's forget all the antics, okay? Remember during jury selection, I said we was going to have a real conversation, right? Real conversation. And the state and I felt like you guys were the most suitable jurors after Verdire, okay? There's three sides to every story. I know you've probably heard that before. One person's version of what happened, another person's version or perspective of what may have transpired, and then there's the truth, right? The truth, ladies and gentlemen, is you at this point. You determine what the truth, what the facts are in this case. You have the ability to give us justice here today, okay? My opening statement, I explained to you all what you would hear in this case. And I submit to you that the defense kept its promise, okay? We kept our promise in this case. This is a case about self-defense. This is a case about reasonable doubt. Now, the state has rested, the defense has rested, and we both are asking you to use your God-given common sense. Consider all the reasonable inferences that comes from the facts that you heard and saw today and throughout the scope of this trial. Consider what you heard, what you didn't hear, what you saw, what you didn't see. Use your common sense, okay? This case is not for the weak at heart. We selected you guys hoping that you wouldn't just have sympathy one way or the other, you know, just unbiased, impartial citizens. This is your highest civic duty to sit on a jury. This is literally the highest mode of citizenship you can have. Sitting right now, being in judgment, to decide whether someone should be found guilty for a crime that they've been accused of, and falsely accused of at that. Okay? I thought about this last night when I was summing up the evidence in this case, and a huge question just jumped out in my mind. And I already had been thinking about it throughout the scope of representing Mr. Doherty, but after the trial, when the state actually presented and showed their hand, you know what that question was? Where's the proof? Where's the proof? The state has a burden, a high burden, that they have to overcome. And I submit to you, the state has not met their burden. They did not. It's not your job to stack inference upon inference upon inference to come to a conclusion that Mr. Doherty did not act in self-defense. If you have a question in your mind right now, an unanswered question, if you have an unanswered question in your mind, about the facts of this case, if something's not sitting right with you, if something's troubling you, if it's something that you would have wanted to see or needed to see to come to a conclusion, and you can't make sense of why you didn't get that, why you didn't hear that, that's reasonable doubt.
Objection, misstatement of the law.
Sustained. I've given you what the instruction is on reasonable doubt. You have it in writing. You should consider that, not what the lawyers argue. Understood?
I'll go directly to the jury. The court has already given to you. And again, you guys use your common sense, okay? And I'll say this a little differently. Mr. Doherty is not required to present any evidence or prove anything at all, number one, right? That's not his job. He could have sat at that table, played tic-tac-toe. He could have been texting if the court would allow. Of course, decorum doesn't allow that, but you get what I'm saying. He didn't have to do anything, okay? Proof beyond a reasonable doubt does not mean proof beyond all doubt. Of course not, right? Reasonable doubt is not merely a possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. If you have an abiding conviction of guilt. On the other hand, this is what I want you to really pay attention to. If after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if you having a conviction is one that's not stable, one that wavers, vacillates, then the charge is not proved beyond a reasonable doubt. And guess what? You must find him not guilty. Not may, you must do it. So, nobody in this courtroom other than Mr. Doherty, I don't know if Ms. Walker's in here, at some point, no one, neither of you, the court, myself, the state, was at 2529 Egret Shores Drive on May 9th, 2022. Right? Everything we say is like our best efforts to try to advise you of what happened that morning around 1:30 a.m. It's a very serious case, ladies and gentlemen. And it's a sad fact that, unfortunately, it's a large sum of people who are murdered every year. And we ask you not to just base this case off that type of sympathy that someone lost his life. We acknowledge this is a very sensitive, sad situation. Both families have been impacted. So out of respect for both families, this is a tragedy. But Mr. Doherty didn't go looking for trouble. When tragedy happens, right, it becomes the duty of law enforcement to be competent, careful, timely, diligent in the performance of those duties, especially when investigating homicides and violent felonies, and doing it without a bias, without a rush to judgment.
So let's talk a bit about what the evidence did show, right? The evidence revealed that neither Mr. Lawrence Doherty or Lawrence Doherty's fiancee, Tatiana Mesa, invited Mr. Payne over. You didn't hear from Tatiana. You didn't hear that from her mouth, that she invited Tara over. Where's the text message? You remember that? Tara Walker wants you to believe she was texted by Miss Tatiana Mesa to come over. Did you see a text message? Where's the proof? The evidence showed that even Miss Tara Walker advised her boyfriend, Mr. Payne, not to go over to Mr. Doherty's house. She admitted to that fact. But why? Why was he there? Why was she there? The crime scene was contaminated. And I'm going to expound upon that a little bit later. That's very important. It's so very important to this case. Fatal to the state's case. It's fatal to the state's case. There was evidence that was not properly secured and processed. Tara Walker's testimony is not credible. There's inconsistency in the state's case. There's lack of evidence in the state's case. And when you go through the jury instructions, that is a factor that tends to go towards reasonable doubt. When there's inconsistency in the evidence, lack of evidence, inability of witnesses to recall what happened, you know. Mr. Doherty's actions were justified under the circumstances of this case, ladies and gentlemen. Mr. Doherty was standing his ground. Let's talk a little bit more about what you heard over the course of the trial, though. Now, in the opening, the state conceded that Mr. Doherty and Mr. Payne had brief words, right? So all this badgering Mr. Doherty on the stand about him allegedly telling a detective that he made no comment, that he just walked out the house and shot this man. Ladies and gentlemen, you heard it on the video that it was verbal. Not only that, Tara Walker, even though she didn't want to really say what happened, she said she pulls into the neighborhood, pulls up to the house, and sees her boyfriend standing outside the car, sees Lawrence Doherty talking to him, and based on her words, communication was happening. Such a soft word, right? They was just communicating at 1:30 in the morning. Just communicating. That's not what happened. The state tried to create some sense of a factual inconsistency, knowing the fact of the matter is that the evidence revealed there was in fact a verbal altercation outside of Mr. Lawrence Doherty's home at 1:30 in the morning, and Mr. Payne's vehicle is outside of Mr. Doherty's house. Feel free to ask for a read back of the opening statement if you don't recall that.
Objection. The opening statement is not evidence.
Sustained.
The state made no mention of Mr. Payne's girlfriend being present during the initial altercation either, because she wasn't. Mr. Payne arrived before her. They didn't meet together. You remember? She was saying that at some point she decided to text him and say, hey, I'm headed over to Tatiana's house. I don't know, something's going on, something. And he took it upon himself, oh, I'm going to go over there too. I'll meet you there. No, don't go. No, I'm already on my way. I'm on the 408. I'm on my way. You don't even know where he stayed at. Driving around the neighborhood, cabins in the neighborhood, looking for my client's car. 1:30 in the morning. So at some point during the verbal altercation, Tara Walker arrives. Mr. Payne actually walks up to her car. And at some point, she tells him to get back in the car and move his car up some more, closer to the house. But do you remember what Tara said? That when she first arrived, that the first person she talked to was Larry Doherty, Mr. Lawrence Doherty's father. And what did Mr. Larry Doherty say to her? Tara, get back. I'm about to go get my gun. Now, if it wasn't a threat that appeared imminent or of some sense of seriousness, that's consistent. Use your reasonable inferences. You're allowed to use reasonable inferences. So that's one fact that's admitted by the state's own witness. The state has proven the defense's case. When Tara Walker pulled up, Larry Doherty told her to get back. I'm about to get my gun. She said, no, don't do that. That's my son's father. That's my boyfriend. Oh, I've never seen him before. That's a big fella. How big is he? Wait a minute, let me see. Medical expert Dr. Hansen said he was 80 inches.
That's fine.
See, what Mr. Payne was doing, he was coming to try to pick a fight. He was trying to be intimidating. He wasn't coming to sing a Christmas carol outside his house at 1:30 in the morning. He wasn't delivering for Uber. He wasn't delivering for Amazon. He had no right to come to his house. Now, if you believe he has a right to be in the street, just parked outside, just waiting, lying in wait for someone with your car running, headlights on, just sitting in the car, and then when someone walks up thinking that you're someone you know, you hop out with a threatening gesture. Mr. Doherty goes in the house. A reasonable person, you know what a reasonable person would do after having an argument outside of someone's home that you don't have a right to be at 1:30 in the morning? And when that person gets ready to go in the house, after you threaten the person and he goes in the house, by the time he comes back out, you should be gone. But guess what? He moved up a little bit closer. And guess what? Mr. Doherty's son was still outside, who was 9 years old at the time, 8 or 9, give or take. His dad was 62 years old. There's inconsistency in the evidence, ladies and gentlemen. There's lack of evidence in this case. So, let's talk about Deputy Garrett Morris. He was very forthcoming and candid, professional. He arrived at the scene. You could see his body camera. He rushed over, and basically he was administering life-saving measures to try to revive or try to just get some sense of keeping Mr. Payne viable till paramedics can arrive. You know, he arrived, he located Mr. Payne in the driver's seat at that time, one left foot out of the vehicle, right foot in the vehicle, you know, but he wasn't all in the car the whole time now. Only after this shot hit him and set him down, he went and got in the car. Because you remember, I was talking about Dr. Hansen. I don't want to jump around too much, but I'm going in the order of where the state called their witnesses. So just walk with me through this journey of justice real quick. Just walk with me for a second. Detective Garrett arrived, pulled Mr. Payne out of the car, and started trying to administer CPR. Okay. He did a brief search of Mr. Payne's fanny pack. He did not see any weapons in there, but he did not search the vehicle at all. Okay? That's pretty much all he did. After this, fire and rescue arrived, and then Deputy Garrett says he maintained the crime scene. Just himself, just Deputy Garrett maintained the crime scene. He testified that he put up crime scene tape. He held the area around the car until homicide and forensics units arrived. Now, he was equipped with body camera footage, remember? Did you see if he maintained the area on that body camera footage that you saw? Where's the proof? Body camera's on. You on duty. You're working. See, the state is trying to cherry pick with you. They're picking to just try to show you some things to try to spoon feed you. You ever had Thanksgiving dinner that was so nasty that you had to sprinkle a little sugar on it to make it taste good? That's what this tastes like. That's what this is. No. Don't let them force feed you. If it's nasty, it's nasty. All right, let's proceed. The state published the body-worn camera footage, and the footage did not reveal that he maintained this area around the car. In fact, there is no evidence that the area around the car was even secured or maintained free of contamination or free of manipulation. Also, Deputy Garrett candidly admitted that when he arrived on the scene, the passenger side door of that black Chevy sedan, that Malibu, was already open. Now, he initially testified that he believed Tara Walker was on the passenger side, but then he couldn't really say that because the door is already open by the time he arrived. All right? And again, he did not search the interior of the vehicle. And I ask you again, where's the proof, right? Somebody gained access to the passenger compartment of the vehicle. That door was completely open. Tara did say at some point in her testimony that she went on the driver's side. I'll get to her testimony in a second. I'm just going to keep going down chronologically. But you know what else jumped out? And I hope you guys asked to watch that video again. If you listen closely to Deputy Garrett's body camera footage, Tara Walker is heard in the background saying, "Why am I here? Why am I here?" You said you was here because you was invited. Seemed more like a setup or something. What's going on? You know, Tara has a motive to not be honest in this situation, because you know what this is? When Mr. Doherty arrived home and he approaches the vehicle that he was familiar with at one point, believing it to be Tara Walker, but unknown to him, a 6'8", 247-pound man steps out and in a threatening manner steps over to him and say, "I'll smoke you. What you want to do?" That's an aggravated assault with a weapon. That's a felony, a forcible felony. And if Tara Walker invited him over to do that, that means she conspired with Adrian Payne to commit a forcible felony of aggravated assault. Use reasonable inferences, ladies and gentlemen. So let's talk about Hannah Miner, the crime scene investigator. She, at the time of this incident, May 9th, 2022, she had only been employed, as a crime scene investigator for 4 months. She had just started January 2022. So she's 4 months in on the job, relatively inexperienced. And it technically shows, because the role of a crime scene investigator is to respond to the crime scenes, document the crime scenes with photos, notes, sometimes measurements, document evidence, collect evidence, process that evidence, package that evidence, forward that evidence to its final location, whether it's in a laboratory or evidence unit, and write reports of their involvement in those cases. And of course, they work in conjunction with law enforcement and detectives. This is her exact testimony, right? It's from my notes, right? But she failed to document and process, collect that knife. She didn't dust for prints. She testified that it can be done, and case by case it can be done. She didn't try to get any touch DNA. She testified that she can do that. It's case by case. So in a case like this, a homicide, allegation, if someone died, that's not something where you think that's important to dust. She agreed that it can be a weapon. It is a weapon. But Tara is saying she's just been driving around with a kitchen knife for 4 months. A mother is not driving around with a kitchen knife on the front passenger side floorboard in plain view for 4 months. That's not believable. Well, one would hope, I think. So May 9th, she was on call, crime scene investigator. Their office is short-staffed. They're only staffed to midnight, so any calls that come in after midnight goes to the on-call crime scene investigator, where they take the call from home. Miss Minor, investigator Minor, she didn't get notified till 4 a.m. This incident, Mr. Doherty arrived at 1:30 in the morning, right? Do you remember the testimony of Tara Walker when she said her brother arrived at 2 a.m.? Follow this for a second. 1:30 in the morning, he gets home. 2 in the morning, Tara Walker's brother arrives. 3 in the morning, Tara Walker's father arrives. 4 in the morning, crime scene investigator is notified, and 5 in the morning, she arrives. 7 in the morning, Tara leaves with her car still at the scene. Crime scene investigator never took a picture of her car, never searched her car, didn't even know her car existed, although Tara was alleged to have been at the scene at the time of this incident. Nobody even took identification from her brother. What is her brother's name? Nobody knows. What kind of car he drive? Tara said a BMW. Crime scene contamination. You heard testimony from Mr. Doherty that he seen her go in the car and run, and she didn't come back out until she was talking to law enforcement, till law enforcement arrived. But what time did law enforcement arrive? The only person you heard from was Deputy Garrett. Where was the other officers, if any? And what time did they get there? How could you secure a crime scene? Where's the proof? It's akin to someone throwing rocks at a glass window, and when you come outside to confront them, they're hiding their hands. Where's the proof? This is serious. This is someone's life. The state wants you to believe that my client just comes out the house, guns blazing, just shooting at someone for no reason, in cold blood, without adequate provocation, without it being in fear, just willy-nilly. Use your common sense. That's not what happened. And it's not the defense's job to show you things that it's not even, it didn't happen. The video that the state showed you doesn't even show the actual, it doesn't show any body, any person in any frame. All you hear, it's a video of audio. It's a video of audio. They didn't, how about this, if this don't convince you? When Mr. Doherty testified and the defense rests, the state didn't even put on a rebuttal witness, no rebuttal evidence. They haven't rebutted self-defense. Their own case established self-defense, arguably. And after hearing from Mr. Doherty, who refuted that? Tara wasn't there when he first encountered Mr. Payne. Now, I imagine what may be troubling you guys is that there was actually no gun found in the car. But it's a reasonable explanation for that. You know why there was no gun found? Because the gun that he had was removed. Either by Tara, her brother, or somebody.
Objection, facts not in evidence.
That's a reasonable inference.
Overruled.
You were allowed to make reasonable inferences based on the facts. That's her job, to collect and document the knife. It was still in the car, not taking in evidence at all. You didn't even have a chance to see it today. I couldn't present it to you. It was not taken into evidence. That's not fair. The state can strike hard blows, but they can commit fouls now. Mr. Payne's girlfriend, her car was on the scene. It was never searched, no picture taken or anything. Investigator Minor agreed that she did not document the vehicle. She wouldn't know what was inside the vehicle because she didn't document the vehicle. And she agreed that part of her duties were to collect evidence, and she failed to document or collect evidence. This means this was an incomplete investigation, insufficient investigation. Marco Quintana, the neighbor, had that Google Nest camera. He didn't see what happened. The actual altercation didn't occur in video, but you just had the audio. He basically just provided them with audio. Not much value to the case at all, other than just at least allowing you to see that an actual argument did happen. You can hear that something happened outside, and then you hear the gunshot. Mind you, Mr. Doherty only fired one shot. It's not like he unloaded a clip. He shot to repel the threat. He didn't shoot to kill. He didn't ask for what happened. Even in the state's opening, he says that Tara Walker speaks with her boyfriend and he decides to come over to the residence as backup. Backup? Backup for what? I hope that you guys, you have to base this case on the facts that you heard in court, not anything external. Not just, this is the case. The facts are the facts, and they didn't meet their burden. They didn't. Tara Walker says that Tatiana Mesa texted her and said, "Meet me at the house in 15 minutes. Did she meet you? Where was it? There was no meeting." It's not right, ladies and gentlemen. You are empowered with the ability to give us justice here today. Justice demands not guilty. His actions were justified. When you go through this jury instruction and look at the justifiable use of deadly force instruction, all those elements are met. It's like, think about this. The elements, you think about elements of any type of crime or any type of rule of law. Think about a peanut butter and jelly sandwich, right? You got peanut butter, jelly, and bread. If you're only presented with bread and peanut butter with no jelly, then guess what? It's not a peanut butter and jelly sandwich. It's missing a necessary element. This is a very simple case. Very simple. Getting back to some of the comments, Mr. Payne, instead of leaving, pulls his car up closer to the home and gets back out of the car. Mr. Doherty again questions, "Why are you here? You need to leave." You can't really hear much of the conversation. Like, it's muffled. It did happen relatively quickly. It happened relatively quickly, you know. And you can see in that video that my client's son was very, very close in the vicinity to this situation. And it was not until Mr. Payne reached in a threatening manner as if he can pull. It just goes back to Dr. Hansen, right? Let's talk about her for a second. She has 35 years of experience. 35 years since 1990. She did maybe 250 to 300 autopsies a year for 35 years. And she testified that the trajectory of the bullet wound that Mr. Payne was inflicted with pierced the tissue of his bicep. Mr. Femur twisted, it just pierced it, and then it went into his chest cavity. But it's consistent with this movement. Thumb down, arms raised. How is this not consistent with someone trying to aim a firearm at you if you're left-handed? The testimony is he was left-handed. You can absolutely aim a gun. I apologize if I'm aiming at you like this, but I really need you to see this. A gun can be aimed like this. This is consistent. And just because the gun wasn't located, but you have a reasonable explanation for that. I can see if you didn't have that. I can see if the crime scene was not contaminated. I can see when law enforcement arrived, the passenger side door wasn't open, wide open. I can understand it if Miss Tara Walker's brother did not arrive at 2 a.m. before law enforcement did. Or at around the time of, had to be before, because he wasn't documented. Was he invited over? Who invited him? Sounds like an ambush. Seems like an ambush. That's a reasonable inference that can be made. Nonetheless, Mr. Doherty reasonably believed that Mr. Payne had a firearm on his person, and there is a strong inference that there was. Either Tara's brother left with the gun, or Tara left with the gun, or the gun was left in her car, or her father took the gun. The crime scene was contaminated before law enforcement arrived there. Tara's testimony should be taken with a grain of salt at best. She didn't even want to acknowledge the fact that Mr. Payne arrived on scene before she did. Vacillating between that. Evasive. You remember when I asked her on cross-examination? Before Mr. Lawrence Doherty walked away and went into his home, he actually asked Mr. Payne, "Why are you here?" Right? Tara Walker says, I can't recall if he said that. Can't recall. How convenient for you not to be able to recall that fact, but you can remember everything else, like the selective amnesia, when a fact is not a fact in your favor. Come on. Reasonable doubt. Come on. How's this justice? How's this fair? Where's the integrity of this prosecution? Remember, the state had the burden to overcome. Remember that. There is so much wrong with this. The integrity of this prosecution cannot be established beyond a reasonable doubt. The state tried to impeach Mr. Doherty about what he said to police, but they failed to show you the interrogation video.
Objection. Halliburton equally available for defense.
Sustained.
The burden is not on us. You hear that? The state want us to provide you with evidence when it's their job to do that. You got to hold that against them. Throwing rocks at a glass window, hide your hands.
Judge, can we approach?
Yep.
Remember, it's their burden, ladies and gentlemen. Literally, this is a homicide investigation. What kind of investigation was this? This case is literally about who do you believe at this point. It's literally Lawrence Doherty versus Tara Walker. No other witness brought any value to this case, ladies and gentlemen. Crime scene investigator didn't collect evidence. She admitted that to you. Maybe due to relatively inexperienced tenure of being a crime scene investigator, but it's not to talk bad about her. She's very educated, obviously. But the state has utterly failed to prove that Mr. Doherty did not act in self-defense. This appears to be some sort of rush to judgment here. You know, some sense, that's what this was. Ladies and gentlemen, Mr. Doherty has exercised his constitutional right to a jury trial. And we truly believe you will make the right decision here today. Justice requires a finding of not guilty. He acted in self-defense of himself, his son, his father, given the darkness of the night, 1:30 in the morning, the size difference. He cooperated with law enforcement. Why was Mr. Payne there? Why was Tara Walker even there? This was a setup. Why didn't they leave? Mr. Doherty was not intoxicated. There's no evidence of this. Mr. Doherty's father drove him home because Mr. Doherty's vehicle was in his own driveway. How else would he get home? Walk with his minor son at 1:30 in the morning? We're not challenging whether the firearm was functional or not. So FDLE testimony from Ms. Kristen Killinger, not an issue. Mr. Doherty testified at 1:30 in the morning. He, his father, and his son was on the way home. As they arrived home, Lawrence sees a car parked at the corner of his home, and he automatically assumed it was Tara. So he thought it was weird that she was parked right there, because she would typically park in the driveway or in front of the house. So Lawrence walks over to greet her, to say, hey, or inquire, why are you parked here? Mr. Payne gets out the car, and when he gets out, he's looking down at Lawrence. He has his hand in his waistband. Lawrence could see something silver sticking out on the side of his hip with his hand on it. And Lawrence asks him, what are you doing here? Mr. Payne replies, this is the words from my notes. He actually said, I'm not playing with you, I'll smoke you. That's what he said. I'm not playing with you, I'll smoke you. Lawrence replied by saying, what? He threw his hands up in the air, started freaking out. Lawrence's dad rolls down the window and asks, is everything okay? Lawrence replied, I don't know. He goes into the home, retrieves his firearm so he could safely get his son in the house. So he returns outside and sees Mr. Payne has moved his car up even closer, and he's gotten back out of the car again. At this point, what do? It's dark. You have no duty to retreat, first of all. If it's troubling you that he didn't remain in the house and go hide in the closet and get on his cell phone and call the police, he's not required to do that. He's protecting his castle. He's protecting his son. He's worried about his father. Why are you here? Can you please leave? Mr. Doherty is 5'8", 145 pounds, had no relationship or affiliation with Payne. Lawrence did not invite Payne over. Out of all the 15 years he known Tara, he had only met that man maybe twice. One time at some girlfriend's mother Thanksgiving or something like that, he showed up unannounced. And he couldn't even recall the other time he met him. Lawrence went back in his house because he felt like his life was threatened. The jury instructions, the law in the state of Florida supports self-defense in this case. This is one for the books. You have the ability to send a message.
Objection, improper, asking of a jury to send a message.
Sustained.
Ladies and gentlemen, we trust you will render justice and make the best decision, one that is fair, one that justice requires. Lawrence was just trying to go home. Lawrence didn't know what Mr. Payne's mental state or his motives. He knew what was going on.
Counsel, your 45 minutes that you imposed on yourself is up. You need to wrap it up. You started at 9:55, it's 10:40.
Thank you, Your Honor. Ladies and gentlemen, we trusted you would do your job today and find Mr. Doherty not guilty, because that's what justice requires. There was no rebuttable evidence. Not guilty. Thank you.
State wish to give its rebuttal?
Yes, Your Honor. The moment. I don't need the lights off just yet. I gotta get the light set up. Thanks. So one of the first things that opposing counsel said in their closing argument was that you should use your common sense. And the state wholeheartedly agrees with that. Use your common sense. We don't ask anybody to check their common sense at the door. The facts in this case, if you look at it using your common sense, you'll see that this defendant wasn't acting like a reasonably prudent person. Now, opposing counsel stated correctly, the state has a high burden in this case. We have a burden of proving this case beyond a reasonable doubt. And that's our burden in every criminal case. Same as a murder case versus a driver's license case, it's the same burden. When we were in jury selection, we obviously hadn't met that burden. The question was asked, I believe somebody, if you had to give a verdict right now, what would it be? Obviously, you heard no evidence, be not guilty. Opening statements aren't evidence. So anything you heard after opening statement, if you had to give a verdict at that point and deliberate, it should be not guilty. But as evidence comes out in this case, that cloak of innocence is stripped away and has been stripped away from this defendant in this case. And with the evidence that's here and the evidence that you heard on that stand, he now sits before you a proven guilty man. So, we do have to meet the elements in this case, and opposing counsel talked about a peanut butter and jelly sandwich, right? So, have a peanut butter and jelly sandwich, you got to have the bread, you got to have the peanut butter, and you got to have the jelly. Those are the three elements. So, a pretty good analogy to the elements in this case. For manslaughter, there's just, the two elements that we talked about, then the three elements for second-degree murder. And that's what we've got to prove. We've got to prove each of those elements beyond a reasonable doubt. But opposing counsel also said in his argument that if you have any questions or any questions about any of the facts in the case, then that's a reason to find the defendant not guilty. That's not true. That's not correct. We have to prove the elements beyond a reasonable doubt. But if you're going back there and you're wondering, well, I have a question whether the victim's car was gray or black. I don't think the state established that. Well, that's not an element. We don't have to prove that. So if you have a question of whether the car was gray or black or something like that that's not an element, that shouldn't influence your verdict. We have to prove the elements beyond a reasonable doubt, and we've done that here. We've made the peanut butter and jelly sandwich, as opposing counsel talked about, because we've hit those three elements for second-degree murder. Opposing counsel talked about a text message that you didn't see the actual text message that Tara Walker, talked about. Okay, I mean, you can believe what you want. Obviously, weigh the credibility of the evidence, but she showed up there. You can use your inference, as opposing counsel said. Why was she there? Right? She said it was because she got a text message. All right, you can decide if that makes sense. Opposing counsel talked a lot about the crime scene being contaminated, but how? You didn't hear anything in the testimony, the evidence of how it was actually contaminated. They infer that somehow maybe with no evidence that the gun was present and was taken. But there was nothing that you heard. Nobody testified to that. None of the evidence you heard showed that. They talked about, Corporal Morris, the first person that arrived on scene. Yeah, he didn't search the vehicle because the first response was to try to save a life because of the actions of this defendant. And his priority at that moment wasn't to secure the vehicle that he was, right next to. And you can see, that he was there the entire time, that the defendant's father was there, that Tara Walker was there. And she was, by the way, hysterical this entire time. From the moment that this defendant shot the victim in this case, and she runs to the neighbor's house to when law enforcement responds, and you can see on Corporal Morris's body cam, she is hysterical. Is this a person that's in that moment just beside herself? She's gonna take a gun or something and try to hide it somewhere? Ladies and gentlemen, in your instruction, it talks about beyond a reasonable doubt, but it also talks about what's not beyond a reasonable doubt. It's not a possible doubt, imaginary of what could have happened with this gun that was never there, speculative, forced doubt. That's what that is. It's imaginary. It's speculative. Now, opposing counsel talked about the height difference between the defendant and the victim. And yes, the victim was tall. He was, 6'8". But this, and you can consider the relative height, but this wasn't a fist fight. This wasn't even something at the time that the shooting happened where they were in arm's reach of each other. It doesn't matter how tall you are when the other person has a gun. And yeah, if the victim and him were engaged in a fist fight, maybe he feels the need to bring a gun out to defend himself at that point. That's not what happened. That's not the facts of this case. So the fact that he's 6'8" doesn't have any bearing on whether his actions were reasonable. They weren't reasonable. Also, opposing counsel talked about, Adrian Payne should have left. Maybe he should have. None of us were there, but there's one person on trial today, and that is this defendant, not Adrian Payne. He's not here today because the defendant acted in the action that he did, and he killed him. That's why. Now, opposing counsel talked about the defendant's son and father being present, but the defendant even acknowledged in his own testimony, begrudgingly, that there were no threats made to his son, there were no threats made to his father. He wasn't protecting them from some sort of threat from the victim in this case. You know, this is a point that I really wanted to address from opposing counsel's argument. He talks about, if you go back and you listen to the body cam from Corporal Morris, you'll hear Terrell Walker say, "Why am I here?" Like, but I mean, it's not like, why am I here? Like this, and like that's some big conspiracy. I encourage you to listen to that body camera. She is hysterical, and she's standing there, and she's asking, why am I here as I watch the father of my child be murdered? Why am I here for that? Why am I living through that? And there's one reason that she was the defendant. Now, there's a lot talked about by opposing counsel about the knife, the kitchen knife that was found in the passenger seat of the vehicle, and why that wasn't collected. Well, this wasn't alleged to be a stabbing case. There was no allegation that anyone was stabbed or that the knife was used. Also, the defendant, in his testimony yesterday, got on the stand and said he saw this silver object. But when I asked him, did you say that in your interview with law enforcement? Well, I don't know. It'd been a while. This is right after it happened. He didn't say it then, but he said it yesterday. Why? Because he got to hear all the evidence in the case, and he got to craft his testimony in a way to try to make it seem justifiable what he did. But even by his own words, he couldn't quite wrap it around the requirements of the law. Because even by his own words, what he did was not justified. Now, opposing counsel is right that when he first had his words, or whatever the case was with the victim in this case, and he went in his house, he was not required to call 911. That's true. He's not required to do that. He's not required to cower or anything like that. But that doesn't mean that because he's not required to do that, that somehow that makes his actions justified. He has to meet the requirements of the law that we talked about previously, that his actions were something that a reasonably prudent person would do. Just because he didn't have to call 911 doesn't mean his actions of arming himself with a gun, coming out and shooting a person that's not in arm's reach of him, not on his property, not armed, is reasonable. So yeah, he didn't have to call the police, but he was not justified in doing what he did. So, opposing counsel talks about defending the castle, defending his home. Again, I want to emphasize to you that the victim in this case never set foot at his house, never knocked on his door, never stepped in his driveway, didn't park in his driveway, didn't park in front of his house, didn't step on his grass. He wasn't defending his castle. He saw a vehicle that he recognized. He went over there at 1:30 a.m., had the person roll the window down, and that's what started the engagement between the two. He did that. He's not defending his castle. And then he went back in, armed himself, and came back and shot the person in his car on the street. So he's guilty. Now I'm going to play for you the clip that shows the audio and then Terrell Walker running afterwards. And you can hear for yourself. You can't see it, but the audio paints a picture. You were asked to come here. Pleading with you. Do not pull your gun out. Do not pull your gun out. You were asked to come here, Lawrence. Notice what you don't hear there. You don't hear anybody yelling, Adrian, put your gun away. Adrian, don't pull your gun out. Adrian, no. You know why you didn't hear that? Because he was the aggressor. He's the one that pulled his gun out. He was the only person making a threat, and he's the person that's guilty of second-degree murder. The state asks that you find him guilty as charged, and you find all of the firearms enhancements that are on the verdict form that you're going to get. Thank you.
All right, ladies and gentlemen, we'll resume with the remainder of the jury's instructions beginning on page 13, starting with rules for deliberation. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. 1, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. 2, this case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence in these instructions. 3, this case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. 4, remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. 5, your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. 6, whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. 7, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think that I prefer one verdict over another. You may find the defendant guilty as charged in the information or guilty of such lesser included crime as the evidence may justify or not guilty. If you return a verdict of guilty, it should be for the highest offense that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict forms have been prepared for you, and I will go over with them with you at this time. The first one is the actual verdict, and then there are 4 special findings that you'll have to make with respect to the firearm, okay? Each of them has a caption, that's the top portion, and it just indicates that it's the case of the state of Florida versus Lawrence Alexander Doherty. It has the charge, the division number, which is assigned to this courtroom, and the case number that's assigned to it, and then it indicates that it is in the 9th Circuit here in Orange County. The verdict form gives you 3 options. The first option is we, the jury, find the defendant guilty of second-degree murder as charged in the information. The second option is we, the jury, find the defendant guilty of the lesser included offense of manslaughter. And the third option is we, the jury, find the defendant not guilty. The bottom portion of all the forms is the same. It says, "So say we all," dated at Orlando, Orange County, Florida, on this blank day of July 2025, and there is a place for the foreperson to sign. When you all have reached your verdict, whoever your foreperson is that you've elected needs to do 3 things on the verdict form for me. You need to check one of the 3 options: guilty of second-degree murder, guilty of manslaughter, or not guilty, one of those 3. You need to make sure that you fill in the date, and you need to make sure that you sign the verdict form, okay? You'll need to make sure that you do all 3 of those things, otherwise the verdict form is not complete. If you don't do those things and you come back and I see that the verdict form is not complete, I'm required to send you back in the jury room, and I can't tell you why I'm sending you back in the jury room. So I'm telling you why now, okay? So just make sure we get those 3 things done. In the event that there is a verdict on either second-degree murder or manslaughter, then you have to do the special findings. If you find him not guilty, then you don't need to make any special findings, okay? The special findings, there are 4 of them. The first special finding says that if you find the defendant guilty of second-degree murder, you then must then answer this question. We, the jury, find the defendant did, during the commission of the crime, actually possess a firearm. The second option is we, the jury, find that the defendant did not, during the commission of the crime, actually possess a firearm. So special finding number 1 is only required if there's a manslaughter, or if there's a second-degree murder verdict from you all, okay? And so then on this special finding, you would do the same thing. You would select either he did possess a firearm or he did not possess a firearm. Make sure the foreperson dates it and signs it, okay? The second special finding also applies only to a verdict for second-degree murder. And it says that if you find the defendant guilty of second-degree murder, you must then answer the following question. And there's 2 options. We, the jury, find the defendant did, during the commission of the crime, discharge a firearm. Second option is we, the jury, find the defendant did not, during the commission of the crime, discharge a firearm. As you did with the other verdict forms, the foreperson will select one of those 2 options, date it, and sign it. And then the third special finding also applies only to the second-degree murder verdict, if there is one. And it says that if you find the defendant guilty of second-degree murder, then you must answer the following question. And again, you have 2 options. We, the jury, find the defendant did, during the commission of the crime, due to the discharge of a firearm, cause death to Adrian D'Angelo Payne. And the second option is we, the jury, find the defendant did not, during the commission of the crime, due to the discharge of a firearm, cause death to Adrian D'Angelo Payne. As you did with the other ones, you would select one of those 2 options, date it, and sign it. And then the last, 4th special finding applies to a verdict of second-degree murder or manslaughter. So if you have any verdict on those 2 charges or those 2 counts, counts, that count or the lesser included, then you would have to do this finding. And it says if you find the defendant guilty of second-degree murder or manslaughter, you must answer the following question. The 2 options are, we, the jury, find that during the commission of the crime, a firearm was personally carried, displayed, used, threatened to be used, or attempted to be used. Second option is we, the jury, do not find that during the commission of the crime, a firearm was personally carried, displayed, used, threatened to be used, or attempted to be used. As with all the other forms, the foreperson will select one of those 2 options, date it, and then sign it. Once you have properly dated and signed and filled out the options for all of the verdict forms that are required, knock on the door, let us know that you've reached a verdict, and we'll bring you in to take it at that time, okay? Now, in just a few minutes, you will be taken to the jury room by the court deputy. The first thing that you all should do is choose a foreperson who will preside over your deliberations. The forepersons should see to it that your deliberations are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict forms when all of you have agreed on a verdict and to bring the verdict forms back to the courtroom when you retire or when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop until the juror returns. You're not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the court deputy. Many of you have had cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or a question or a verdict. Other party wish to have the jury pull. Bring the jurors back in. All right, go ahead and have a seat. State recognize the presence of the jury?
Yes, Your Honor.
Defense recognize the presence of the jury?
Yes, Your Honor.
All right, has the jury reached a unanimous verdict? All right, if you'll go ahead and hand the verdict forms to the court deputy for me. All right, the verdict forms are in order. Madam Clerk, if you'll go ahead and please read the verdict.
In the Circuit Court of the Ninth Judicial Circuit, in and for Orange County, Florida, the state of Florida versus Lawrence Doherty, case number 2022, CF 5250. Verdict as to count one. We, the jury, find the defendant guilty of second-degree murder as charged in the information. So say we all, dated at Orlando, Orange County, Florida, on this 30th day of July. Bill person. Special finding as to count one. If you found the defendant guilty of second-degree murder, you must then answer the following question. We, the jury, find that the defendant did, during the commission of the crime, actually possess a firearm. So say we all, this 30th day of July, 2025, at Orlando, Orange County, Florida, sign the foreperson. Special finding as to count one. If you found the defendant guilty of second-degree murder, you must then answer the following question. We, the jury, find that the defendant did, during the commission of the crime, discharge a firearm. So say we all, this 30th day of July, 2025, at Orlando, Orange County, Florida, sign the foreperson. Special finding, if you found the defendant guilty of second-degree murder, you must then answer the following question. We, the jury, find that the defendant did, during the commission of the crime, due to the discharge of a firearm, cause the death to Adrian DeAngelo King. Special finding, if you found the defendant guilty of second-degree murder or manslaughter, lesser included crime, you must then answer the following question. We, the jury, find that during the commission of the crime, a firearm was personally carried, displayed, used, threatened to be used, or attempted to be used. So say we all, this 30th day of July, 2025, at Orlando, Orange County, Florida, sign the foreperson.
Either party wish to have the jury polled?
The state does not.
Defense does, Your Honor.
Madam Clerk, if you'll poll the jurors for me, please.
Juror number 902, is this your true and accurate verdict? Is this your true and accurate verdict? Juror number 558, is this your true and accurate verdict? Juror number 206, is this your true and accurate verdict? Juror number 4217, is this your true and accurate verdict? Juror number 484, is this your true and accurate verdict?
Yes.
Juror number 693, is this your true and accurate verdict? Thank you.
All right, ladies and gentlemen, I have one final instruction for you, and that is your instruction upon discharge. I do wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges that you enjoy as jurors. No juror can ever be required to talk about.
All right, so we know he basically was found guilty of that. So I'm just gonna wrap up our little stream today. I don't see anything else that's really interesting. And honestly, y'all, I'm about to get out in these streets and go get school supplies for not only myself, but for the children. It is tax-free weekend, and I absolutely want to go and let them go do the school shopping experience. I usually buy their school supplies online, to be honest. And then just throw everything in everybody's book bag and say, good luck on your first day. But we're gonna go out today and go into the stores and let them pick up their little items off their little list and just kind of enjoy the day with each other, right? We are down to our last 18, well, I can't say 18, right? 17 days. So in 17 days, I will have a 7th grader. I'll have a 6th grader, a 1st grader. Molly's still going to daycare. I will be a 1L.
1L law student. But this isn't goodbye. This is not a goodbye. Thank you, Beta. Oh, I appreciate that. It's not goodbye though, right? Because we've got our Discord chat. We can always go and raid other people's chats. You know what I'm saying? We can stay together as a gang in these internet streets, you know, and be in the chat with each other, even though I won't be able to stream it and keep our community together and keep our environment safe. But we'll we're gonna be in touch. We won't be out of touch. And I'll still also produce content. Like I felt like I did a lot of hard work on Melly. And for me to let the Melly trial go without me having any type of recap, it's just not gonna happen. And then we absolutely have to support Arian. Okay, Arian is out here representing Alicia in the Julio Fulio trial. And so we gotta support our girl Arian. You know, I love me some her. So I'm gonna try to keep up with that trial as well. Y'all do know I gotta commute. So I got I got to ride like an hour and a half to school and back each day. So I do plan on listening to the trial. So just make sure that y'all stay in the Discord. Make sure that y'all post what y'all watching so that I can know what's going on out here in the world. Because if y'all don't tell me, how I'm gonna know? How I'm gonna know? Thank you, Skin. I appreciate that. I'm gonna miss y'all. Like y'all are an integral part of my day. Very intricate part of my day. I don't like other people. This is a see you later. It's not a goodbye. I promise it's not a goodbye. You know, our channel is graduating, right? We were outside the courtroom and now we're going inside. So I will still try and create some lives and maybe we can talk about what's going on in these cases and maybe we can talk about just some of the things that I'm learning along the way. They say that the 1L year is crazy, but I made a promise to myself last night that I will not let it break me. I will not let it tear me down. I will not let it get the best of me. And I'm going to try and still maintain some part of normalcy in my life because I hear that it will truly consume you. I personally have never taken 18 credit hours in one semester anyway. So I am, my eyes is buck. My eyes are buck. Looking at that schedule, but I know it's gonna be just fine. It's gonna be just fine. Thank you, Tally. I'm gonna miss y'all too. She's asking who's gonna stream Alicia Andrews. I'm not sure. I wish you so much success in your endeavor. You'll be a great lawyer. Thank you. I appreciate that. Go be great, TU. Thank you. And here's the thing. I'm a miss TU, period. Just the whole brand of TU, because they're gonna be calling me by my government name, which I gotta get used to. Because I'm not. Oh, gosh. I don't know who's gonna stream it, but I'm sure we're gonna figure it out. We're gonna figure it out. We're gonna be in them comments, we're gonna be in that Discord chat, and we're gonna figure out who's watching. Okay. We're gonna figure it out. And y'all know I can always pull a transcript. Okay. So if I miss court and I'm on my way home, I can pull a transcript and get a summary of what did happen. So don't ever forget it. I can figure it out. Thank you, T. I'm so proud of you. I wish you so much luck on your LSAT journey, girl, because it is no joke. And like I told you, the answer is right. Just be confident in whatever you pick. Don't second guess it. And you got this, girl. You got it. It don't matter how many times you got to take it, or how many answers you get wrong. You're going to get the score that you need to get to where you got to go. Where do I find the Discord? So the Discord, we'll have to post can somebody get the Discord link in here? Let me see if I can get the Discord link. Let me see if I can get the Discord link in here for you. Okay, I got it. Now I just got to get over to YouTube on my phone. I know. CB not in here to say goodbye on the stream. CB, where you at? Okay, that's the Discord. They say, CB, get in here and say something. And 1L sucks, but it's only 1 year. Once you get through that, you got it in the bag and you will get through it. Thank you, Erin. I appreciate that. No, you are so welcome, girl. And if you need any tips and tricks, let me know what you stuck on. I'm gonna tell you exactly what I did to get over that hump. So the majority of African Americans actually score a 148 on their LSATs. And to be honest with you, it was a score that I got too. I got a 148 before too. So don't let it discourage you. I've seen so many different other creators and just students who vlog get into law school with low LSAT scores. It is only one metric and one piece of your application. It does not define who you are, and it will not determine the type of attorney you will be. Now, don't get me wrong, I'm passing this information along, but it definitely helped me when I received it. So just take it, T, and push, girl, because you got this. Sharonda, I know, girl, I know. Thank you, Claudia. I appreciate it. Thank you for being you and making me feel welcome. Absolutely. You always welcome her. I don't know where CB is. I don't know where CB at. He sent me an email this morning and he actually told me that the Maxwell Anderson trial was streaming, and Shay texted and said the same thing. And I haven't seen him in the chat. So CB, if you in here lurking, CB, hey. But I know CB gonna be sending me emails on these court cases too. So I know if anybody gonna keep me up to speed, it's gonna be CB too. He gonna make sure he do his part. He gonna make sure he do his part. Okay, y'all. So I'm gonna wrap up my last final things over here at work, and then I think I'm gonna be gone for the day. So thank y'all so much for participating in the actual live stream. I know we kind of called it the last one on yesterday, but that was just our last big one, right? So I just want to thank y'all so much for just rocking out with Taylor Umbridge, just period, right? From YSL to Tim to what was that other trial that we watched, y'all? What a man, the Vermont man, the honeymoon massacre. I don't know if you ever remember that trial. We watched that trial. We watched so much stuff together, y'all. I had wrote out a list of superlatives because I'm so lame. I wrote out a list of superlatives, and I gotta give them out to y'all real quick. I almost forgot to. I wrote out a list of superlatives. Hold on, let me find it. One second, y'all. Okay. All right. So, most likely to support whatever you do goes to Beta, y'all. It don't matter what is going on, baby, Beta gonna be there. If she could be there, Beta is going to be there. So I gave most likely to support whatever to Beta. Most likely to pass an open book test. I think y'all all know this goes to Shay. This goes to Shay because if anybody taking notes, Shay's notes was the Bible in the TU channel, okay? If we had a question, if we got something wrong, we knew that Shay was going to have them notes, okay? So I voted her most likely to pass the open book test. Now, this one is going to be a no-brainer, right? But most likely to get the ladies, went to D Wood. Because it didn't matter which trial we was in. D Wood was checking out somebody. Okay? He was letting us know who he was with and who he was against. Most likely to protect the ladies. I gave that one to KP. I know KP not in the building right now, but KP be standing 10 toes down on everything. 10 toes down on everything. Most likely to cry, I gave to Kim. Because y'all know Kim always crying about a trial. I love me some Kim. Kim was most likely to cry. Where's Kim at? I'm looking for her. I don't think I've seen her today. CB not in here, but I did give CB an award to y'all. His was most likely to object. Because, baby, one thing about CB, if you ain't got them facts together, baby, objection. He does not agree with that. What you doing is out of bounds, it's out of line, and it ain't a part of the law. All right, so I gave that gift, that one, that superlative to CB. So thank y'all again. I absolutely love y'all. I love our community. We are going to continue to learn and grow, and just be better, y'all. Just be better. Just be better human beings after watching these cases. Child, you got to be. You got to be. I'm gonna give Skin an honorable mention because Skin she's an A1 day one too. And I'm sorry I forgot to give you a superlative, girl, but you A1 day one for sure. CB fact check me one day. For real. He stay fact checking. Yep, Sonya, LaRon. I don't know if y'all remember Gaston. He used to come in here a whole lot. Chloe used to be in here a lot. Jen. Jen. We missed Jen after we went down the Memphis trial. It went downhill after that. We hadn't seen Jen in her as much, but she did do our last trial with us. So Cavell, Hassan, Hassan used to be in here a lot. Shout out to all of the other law tubers though. So Katnai Williams, Flesh of the Gods, Mel. I'm not a lawyer, but that's my girl. Okay, y'all. Now I'm just shouting people out just because I don't want to get off of here knowing that this is the last thing. So I'm gonna go cry in the car. But be on the lookout. Keep your notifications on because I will still push content. It may just be a little different, but we're gonna still push content out here. So I'm gonna see y'all in the Discord chat. Bye.